My lord, I may pardon to make one mention. I am from VC, my lord. I am from VC. I am from VC, my lord. Item number 1 for judgment.
With our considered view, the conviction of Chandra Guru, appellant number 1, with aid of section 34 IPC has not been proved, and hence Chandra Guru, appellant number 1, is acquitted. As regards the appellant number 2, Jara Singh Guru, the judgment and order of the learned trial court is found correct and is confirmed.
I agree. Yes, somebody was mentioning something.
My lord, I may pardon, my lord.
Yes.
I am from VC, my lord. My serial number is 16. I have from JCRLA 58 of 2008, my lord. I am ready by seeing the judgments, my lord. But I may be permitted to take that paper book so that I will argue after tomorrow or Friday. Whatever my lord will fix, I will argue that matter, my lord.
No, it is a 2000 matter,
My
2008 matter, and it must
Okay.
be there in the hearing list for at least 2 months back, since 2 months. So why have you not collected the paper book?
My lord, in the meantime, my mother passed away, my lord, for which I could not come to court, my lord, for which there the hindrance, some problem.
You get
From
the
my
paper
part.
book today and get prepared. By day after tomorrow, we'll take up this matter.
Obliged.
Yes.
Friday, my lord. Obliged.
Call the matter seriously.
Item number 2. May please, your lordship. The petitioner minor daughter has been missing, my lord, since 10/4/2023. In this regard, we have filed a FIR. FIR has been registered, my lord, but no investigation has been conducted, my lord.
What is the age of your daughter?
Yes, my lord, next page 13, my lord, is identity card. As per it is the first year student, my lord.
No, age ପଚାରୁଛୁ first year student ପଚାରୁନୁ ଆପଣଙ୍କର date of birth
16 years. 16-17 years.
You suspect somebody you have not named anybody in the FIR. So this FIR was lodged on 11/4/2023.
My lord.
Are you suspecting that any kind of relationship for which she might have fled away with somebody, eloped with somebody?
Suspect as per the annex 2, page 11, one name has been mentioned. Indradeep Pita Shivadeep.
Ki pila se? Same village or
Same
college?
village, same village.
Same village.
My lord.
He is also found absent from the village. ଆରେ ଆପଣଙ୍କ ଗାଁର ସେ ପିଲା ସାଙ୍ଗରେ ଯଦି ସସ୍ପେକ୍ଟ କରୁଛନ୍ତି ଲେଖିଛନ୍ତି ପୁରା ଅପହରଣ କରି ନେଇଛି ପ୍ରଶ୍ନ ପଚରା ହଉଛି ସେ ପିଲା ଘରେ ନାହିଁ କି ଆପଣ କହୁଛନ୍ତି ମୁଁ ଜାଣିନି ଆଉ କିଏ ଜାଣିବ ଯଦି ଆପଣଙ୍କ ଝିଅକୁ କୌଣସି ପୁଅ ନେଇଯାଇଛି ଆପଣଙ୍କ ଗାଁର ଆପଣ ସସ୍ପେକ୍ଟ କରୁଛନ୍ତି ପ୍ରଶ୍ନଟା ଯେତେବେଳେ ହେଲା ଆପଣ ଉତ୍ତର ଦେଇଦେବେ ନା ଯେ ନାଇଁ ସିଏ ବି ମିସିଂ କରୁଛି ବା ସିଏ ବି ଗାଁରେ ନାହିଁ. So it is coming for the first time.
My lord.
So Mr. Das, you obtain instruction about particularly that boy's name has been given there FIR ରେ ତ unknown ଅଛି।
କପି ଦେଇଛନ୍ତି ଉପଜିଲ୍ଲା ଟିଟଲାଗଡ଼।
ये जो ग्रीभांस पिटसन टा जोटा लिखिଛନ୍ତି ସେଗୁଡାକ
They also appear with the IAC and also inform this matter. I will inform the IAC also.
you just
Yes.
take instruction about the status of the
Right.
case and you will cooperate. He must have been the statement must have been recorded and you produce these what steps have been taken. Lekhandu. This writ petition has been filed by petitioner Ram Bhavati Hans with a prayer for rescue of his missing minor daughter and to produce her before this court. The learned counsel for the petitioner submitted that in connection with the kidnapping of our minor daughter, the petitioner lost the first information report before the inspector in charge of Muri Bahal police station in the district of Balangir on 11/4/2023, and accordingly Muri Bahal PS case number 59
59.
59 of 2023 was registered under section 363 of the Indian Penal Code against unknown person, and subsequently a grievance petition was filed before the sub-collector Titlagarh, wherein the name of one person, namely Indradeep, son of Shivadeep, has been mentioned to be the kidnapper of the minor daughter of the petitioner. But even though in the meantime more than 7 months have passed the date of lodging of the first information report, no sincere steps have been taken by the investigating agency to trace out his minor daughter and to apprehend the person responsible for such kidnapping. The Land Counsel for the state has received the copy of the writ petition and seeks some time to obtain instruction about the status of the case. So also steps taken by the police to rescue the victim girl and also to apprehend the person responsible for such kidnapping. The inspector in charge /IO of the case shall remain present on the next day with the up-to-date case diary, so also the details of steps taken for the rescue of the girl. Please this matter under the so let it come on 18th of December 2023. Free copy of the order be handed over to the Land Counsel for the state. Mr. Das, it will come on 18th, huh?
You also answer whether any bail application has been filed or not. All right, that will all help.
That man, you Shibo, Indradeep. Yes.
Item number 3, please your lordship. The same appeal has been filed for restoration of the matter which is dismissed for default. 8/9/2014.
My lord, I am for the respondent husband.
So 2014.
ଆଜ୍ଞା ମେମୋ ବହୁତ ଦିଆ ହେଇଥିଲା କିନ୍ତୁ ତାପରେ ଆସିପାରିଲାନି।
Memo ଆସିଲାନି କଣ 2014 matter ଟା, but there must be respondents ସେ ତାପରେ ବହୁତ ଜିନିଷ ହେଇଯାଇଥିବ, ଏଟା କଣ ପାଇଁ ଆପଣ ଆସିଥିଲେ?
The husband got married after dismissal of the appeals.
So no ଏଟା କୋଉ order against ଆସିଥିଲେ?
divorce petition
Divorce
section 9.
and
Mata in the Mata, who was the petitioner in the
Both.
before the family court,
The husband.
husband.
My lord.
So what happened to the divorce petition?
Allowed.
Allowed.
Uh,
Then the wife challenged here.
Yes, but I challenge her.
You are for the wife.
Wife.
And you filed that, and that was dismissed for non-prosecution.
Non-prosecution.
That was in the year 9/9/2014.
My lord.
So that period has elapsed. He has already got married.
Only
Sorry?
thing I pray that so far the alimony is concerned, that may be considered
Alimony
for
is
that
satisfied.
purpose.
Huh?
He
But
has already paid.
only
No,
2
no.
lakhs was paid.
What is the amount?
2
2
lakh.
2 lakhs.
2 lakh. So you have already received.
Yes.
The received, he was on objection, he was not received so far.
No,
but
no, he
yesterday,
received. She received.
but I will take instruction. But yesterday I was a telephone but did not respond.
No,
I have got the AD.
you see,
So whatever
Remand draft
you
was
are
sent.
for the wife, that's all right. But that doesn't mean that
But it should
you
not
sleep
say that.
over the sleeping lion has no say. That is the
Man.
so even if you have a good case, but if your case will not appear and that is dismissed for non-prosecution, and you will file the restoration application after 9 years, then what will happen?
Immediately there 2 days after the restoration file 2014.
File টা କରିଦେଲେ କଣ?
ତାପରେ ତ
No, are you aware or not? If the
that
within a certain limit,
My
if from the date of so and so he's not any interim order is passed, then he can remarry.
base that
So-
90
so-
days there.
So she has already remarried, and
Only
you have got the that amount. So now what can be done?
even though received, my lordship, consider the amount is
Arey,
2 lakhs only or child.
No, he is producing. Have you got the document that he has? She has
Says
no?
acknowledge.
Acknowledgement.
So if for your satisfaction, you can take up this matter tomorrow.
I'm just the 2 lakh though received. The lords may consider whether 2 lakh is sufficient enough.
Unless that matter is restored, how can we consider?
And that is for that purpose. But for that purpose only I pray to be restored to extend the benefit
He was
of his
also blessed
justice.
with his son, which is 7 years
On
old.
the second marriage,
Yes.
that means after divorce. So it would unsettle everything. Just imagine. And,
No, I'm not saying that for restoration of marriage, only to the extent of computation of to alimony.
Is there
If that
suppose a permanent alimony is fixed, and just think there are you will get the case law also. A permanent alimony is fixed. Okay, so due to price rise, okay, at one point of time after so many years, the wife faces the difficulty. He is not able to maintain herself. So is he debarred to file any further application to enhance that or not? That you can verify. You may get some.
I will examine.
Okay.
That man.
Section 25 of Hindu marriage. So that amount is can be altered, that can be changed also in the change of events. So if your relief is only for that, you can get it. So
only for that, because once there is no relationship since long.
But have you made out a case for that? Because you say that you have made the application in 2014. By then, this ground was there.
Yes, ma'am.
You are not coming after 9 years for that. Immediately after that, you have already filed.
Yes.
So, is this ground?
Only for restoration, because appeal has not been taken up for hearing.
All right.
So that chapter is closed. Now, question is, suppose that matter stands as divorce is confirmed. Okay. So question is, what you are now seeking relief, this permanent alimony, the amount is 2 lakhs. That must be in the 2014. We are in 2013. So whether law permits you to file any application for any enhancement of that amount or to get any monthly dues or anything like that in view of the provision of law or the change in circumstances. That you examine, you may, but that is to be filed before the concerned court, not here. Okay, that is to be filed before the appropriate court. If they clear it, Hindu Marriage Act 25 indication they are. Yeah. Permanent or any court executing the action of this court at the time of person petition or any subsequent application by the right based on all the terms. Pay one year periods one sitting life would be applicant as well as the own income other property income on the premium or necessary it to be just when interest and ask you to by the change on the if the court is satisfied by the change in the subsection provided by at any time after it has made the order on which you answer, it's near the instance of either party. That will not be so that is if the court is satisfied the party in which favor the order is made one for the invalid or each of party device that's the payment chased and is partly the extent that he has placed on so that's the different matter. But it will come within this change in the circumstance. But the price rise. So this is for permanent element, again above interment will be Javi and mental. So both from yes, so
You take recourse to section 25. Have you seen it? You take recourse to that.
So look on this CMAPL has been filed by the petitioner Susmita Parija alias Mahanti, who was the appellant in MATA number 18 of 2012 though? 2012 for recall of the order dated 9/9/2014 passed in the
15 by
সেটা 15 by 12
2012
এটা 18 না 15
15 by 2012.
5
এটা 18
ঠিক আছে 15 of 2012 to for restoration of the file for hearing in the interest of justice. Needless to say that the husband hyphen opposite party Hemant Kumar Mahanti filed a divorce petition before the Learned Judge Family Court Cuttack, which was registered as kete number seta thila
40
CP
CP
CP number say CP number ta kona
206 2006
CP number 206 of
2006.
2006
Yes.
6 for divorce and the prayer was allowed by judgment and order dated
4/1/2012.
4/1/2012. The petitioner wife challenged the order passed by the Learned Judge Family Court before this court in the aforesaid MATA 18 of 2012.
15.
কেতে 12
15 by
15 by
2012.
15 আছে 15 of 2012 which was dismissed for non-prosecution as per order dated 9/9/2014. Though this application for restoration was filed in the year 2014, as appears no sincere steps have been taken for listing the matter, and after 13/4/2015, no order has been passed in this petition. The Learned Counsel for the opposite party husband submitted that after dismissal of the MATA, as per order dated 9/9/2014, the opposite party has remarried to another lady, and he is now blessed with a child. And as per the judgment and order passed by the Learned Judge Family Court Cuttack in the divorce proceeding, he has deposited a sum of rupees 2 lakh towards permanent alimony as awarded, and she has instruction that the petitioner has received the same. The Learned Counsel for the petitioner argued that rupees 2 lakhs which was awarded to the petitioner towards permanent alimony is a meager amount, and it is very difficult on the part of the petitioner to maintain his livelihood with such amount, and at least the amount be enhanced. The Land Council for the opposite party opposed to such prayer. During course of argument, however, the Land Council for the petitioner submitted that since in view of the provision under section 25(2) of the Hindu Marriage Act, he can get the relief sought for here towards the enhancement of the permanent alimony fixed by the Learned Judge Family Court, Cuttack. Before the said court, he seeks permission to withdraw this CMAPL to seek appropriate remedy before the competent court. In view of such submission made by the Land Council for the petitioner, the CMAPL is disposed of.
One thing I may premise, there is another matter of soul of bar. There was a CP bar 42 of 7, section 18 was filed. The common judgment it was there. That may be disposed of so that things can be.
No, that is not in
Not in
court.
Sorry. Okay. Yes, next.
Item number 4.
Pleasure, my lords. This is a application challenging the judgment of acquittal. Respondents 1 to 6 were the accused in the court below, and they were charged for commission of offences punishable on section 452, 294, 354, 384, 302 of the Indian Penal Code, reduced section 13(3)(1)(x) of SC/ST Prevention of Atrocities Act. Ultimately, what I gathered from the judgment of the Long Trial Court, the deceased was found hanging in a tree, and the doctor who was examined in the trial court as PW7, he has not expressed the opinion in the PM report or in the examination chief that whether it is a suicidal hanging or homicidal. Ultimately, a question was asked from the side of the defense, which was relied on by the Long Trial Court, that it is a case of probable committing suicide. So far that offence is concerned, though at present I am not pressing the or arguing the matter.
302.
So far the other offences are concerned. I examined the judgment commencing from para 15 to onwards, and it was not, the evidence on record was not properly appreciated and adjudicated. So I think so far those offences are concerned, it is a matter which is to be reconsidered by this honorable court by admitting the
Mr. Mahapatra, if
Madam.
302 goes, then the other offenses are 452, 294, 354, 384, and 3 SC/ST Act.
Yeah.
So,
And 3 SC/ST Act.
right.
Mm.
So, what are the materials and it is a case of the year 2005. 2005. We are in. So GR case is 2005. So FIR must be also in 2005. So 18 years have passed, and for these offences, this 452 and you yourself fairly submitted that 302 it not be there. So
My lord,
yes,
that is true. I am
now-
not
now
pressing that.
for these offences after 18 years, whether if Mr. Mahapatra would have been the defense counsel, then I hope he would not have said so.
I accept not as a petitioner, appellant's counsel, but as a officer of the court, I accept your lordship's proposal.
ଆଉ ସେ ବଡ ଅଫେନ୍ସ ଟା ଛାଡିଦେଲେ ନା ଆପଣ ଇନଫ୍ୟାକ୍ଟ ନାଇଁ ଆଉ ଏ ଛୋଟ ଛୋଟ ଗୁଡାକ ଦେଖିକିନି
why this? Actually, what I gather from the evidence on record, there is a clearly atrocity committed by the respondent number 126 because these appellant and his family members are a small group in a village. On the night of the occurrence, what happened? The deceased was in love with the sister of the respondent. So a nirbandh was held. Ultimately, the deceased came to the
house of the
suspected that concealed in the house of the
No,
appellant.
she left her house. Maybe on that day the
No, Mr. Mahapatra,
bride
another
left
thing,
here.
if you find the cause list today, the GCRLA matters or GA matters are of 2002. So 21 years have already passed. So if we admit one matter today, after 20 years means 2005 ରୁ ଆଉ 40 ବର୍ଷ ପରେ ତେଣୁ ତା ଦେହରୁ ସେତେବେଳେ ବୟସ ହେଇଯାଇଥିଲା 50 ବର୍ଷ ତେଣୁ ସେ ଲୋକ ସବୁ
ଥିବେ କି ନାହିଁ ସନ୍ଦେହ
ତେଣୁ
କିନ୍ତୁ ଗୋଟେ କଥା ଏଇଟା ଗୋଟେ ଚେକ୍ ଆଣ୍ଡ ମେଜର ପାଇଁ ରହିଛି ଖାଲି ଚେକ୍ ଆଣ୍ଡ ମେଜର ultimate I accept everything what your lordship proposed to me. Ultimately what will happen, the fate of the case, I am our, but it will give a check and balance.
All right. The this PRLA has been filed by the petitioner, appellant Amulya Malik,
who happened to a mother of the deceased,
who is the mother of the deceased, Sukanta Malik, challenging the judgment and order dated 23/2/2017 passed by the London Special Judge Kendrapada in ST case number 30 of 2007 in acquitting the respondents of the charges under section 452, 294, 354, 384, 302 of the Indian Penal Code and section 31X of the SC/ST POA Act, read with section 34 of the Indian Penal Code. The prosecution case in short is that on completion of investigation, charge sheet has been submitted, and during course of trial, prosecution examined 11 witnesses. After assessing the evidence on record, the Lenin trial court came to hold that so far as the offense under section 302 of the Indian Penal Code is concerned, the doctor
EW7.
PW7 who conducted post-mortem examination has stated in the cross-examination that the ligature mark on the neck of the deceased is a case of suicidal hanging, which itself disproved the assertion of the prosecution that the deceased was being murdered and the accused persons bracketed opposite party therefore cannot be held liable for the offense under section 302 of the Indian Penal Code. The London Trial Court further discussed the evidence of PWs 1 to 3 and 5, 1 to 6 कर दूं, 1 to 6 and held that on a threadbare evidence analysis of the oral evidence of the prosecution witnesses, mere suspicion about the accused persons killing the deceased have been expressed, but the medical evidence of the doctor shows the indicate the possibility of suicidal death and therefore the charge under section 302 IPC cannot be sustained. The London trial court then discussed the evidence of the prosecution for the offense under section 294 of the Indian Penal Code and so also the under and held that the prosecution case never revealed about the occurrence taking place in public place, nor any outsider is being examined in this case to say that any annoyance was caused to them. And if the evidence of uttering oblique abusing the informant family are taken to be true, no offense under section 294 can be substantiated by the prosecution. The London trial court also discussed the evidence of material witnesses PWs 1 to 6 relating to the offense under section 354.
Your Lordship may say PW 1 to 6 and 9.
PW 6 and it was held that the PW1 has not whispered any word about the outraging of modesty of any female members of his family, nor he had seen the accused persons using criminal force on any woman. PW2 has not stated a single word in his evidence about the accused persons outraging the modesty of any female, and similar is the evidence of PW3. PW4 has also not whispered a single word about the accused persons outraging the modesty of any female. And ultimately, on the careful and meticulous analysis of the evidence, the London trial court has come to the conclusion that there is hardly any evidence about the opposite parties outraging the modesty of any woman, and therefore the prosecution has not been able to establish the accused person outraging the modesty. of the victims. The Learning Trial Court then discussed the charge under Section 384 of the Indian Penal Code in paragraph 16 of the judgment, and came to hold that there is hardly any evidence on record that the accused persons inducing the members of the informant party by putting in fear of any injury to deliver any property or valuable security or anything signed or sealed which may be converted into valuable security. And and though it is alleged by the prosecution that the accused persons dishonestly induced Divakar Malik, Prahlad Malik and Pramod Malik to deliver a signed document, but neither Divakar Malik nor Pramod Malik has been examined in this case, the prosecution therefore cannot be said to have established that the accused persons put such persons in fear of injury dishonestly by induce them to deliver a signed document. Learning Trial Court then discussed the charge under Section 31X of the SCST POA Act, and held that though the PWs 1 to 6 supported the prosecution case, but there is hardly stated about the accused persons insulting or intimidating the members of the informant party in a place within public view. The essence of charge under Section 31X of the Act lies in the insult oblique intimidation of a member of either SC or ST community in a place within the public view, and the term public view denotes to mean that public must view the person being insulted. And since except PWs 1 to 6, no outsider are stated to have seen the occurrence, and it was held that the prosecution cannot be said to have established such charge. The London Trial Court also discussed the evidence of evidence on record relating to charge under Section 452 of the Indian Penal Code, and held that PW1 has failed to state about the accused persons entering into the house of PW6. And PW6 has not whispered about the accused persons taking away his father and two uncles, and it is therefore unsafe to rely on the evidence of PW6 to find out the guilt of the accused persons for house trespass, as the evidence available on record in this regard are not consistent. After carefully going through the impugned judgment and hearing the London Counsel for the petitioner, we are of the view that the London Trial Court has discussed all the material evidence on record, and the view taken by the London Trial Court cannot be said to be perverse, and or there is any illegality in any of the findings arrived at by the Learned Trial Court. In view of the settled position of law as discussed by the Honorable Supreme Court in case of so 83 Supreme Court 30, that if two views are possible, then the view is favors the accused to be taken into account, and therefore we find no reason to interfere with the impugned judgment, and accordingly we are not inclined to accept the prayer made in this criminal appeal. Accordingly, the criminal appeal stands dismissed. Yes.
My lord, before parting, may I say one thing? Not this case. What I examined from the record, the trial court, they are not conscious what is the duty while framing charge. That is the most important thing. Though in most of the cases I am appearing on behalf of defense, but the prosecution here is a case, there is a suspicion whether a case comes within the ambit of section 302 or 306. So my humble submission, in that situation, when the court is not definite at the time of framing charge, alternative charge should have been framed. So thereby justice could have been done.
No, it was also the duty of the public prosecutor to bring it to the notice of the court.
Exactly.
Because that is why the police papers are supplied. That is why everybody gets a chance to have their say at the time of framing of the charge. But if it is mechanically done, and obviously most of the cases charges are framed as per the charge sheet file.
Exactly.
So they think that all the offenses, it will be seen at the latter stage. Why not frame all the charges? So some of the charges are missing, of course, and there is a provision for alteration of charge. But
that will again delay the matter.
because the recall is to be done, all these things.
କଣ ହଉଥିଲା କି ମୁଁ ଯେତେବେଳେ ଇନିସିଆଲ ଷ୍ଟେଜରେ ରହୁଥିଲି ଚାର୍ଜ ପାଇଁ ସମସ୍ତେ କନସିୟସ ଥିଲେ, କୋର୍ଟ ଥିଲେ, ପ୍ରୋସିକ୍ୟୁସନ ଥିଲା, ଡିଫେନ୍ସ ଥିଲା, ଚାର୍ଜ ପାଇଁ ହିୟରିଂ ହଉଥିଲା। ବର୍ତ୍ତମାନ ମୁଁ ଯୋଉ ଦେଖୁଛି ସେ ଚାର୍ଜ ଖାଲି ନାଁକୁ ଅଛି, କହିଦଉଛନ୍ତି ସେ ସରିଗଲା। ନନ୍ ଅଫ୍ they are applying their mind and they are forgetting that it is a very foundation of the case where from court will proceed further and collect evidence. ସେଇଟା ଗୋଟେ nowadays that is the whole problem.
Because there are some
why I am drawing this fact to my lord's kind attention. Whenever there will be a training program, your lordship may ask the presiding officer, they will be conscious what is the importance of the framing charge.
Because there are some decisions that if you do not frame a charge under section 306, if you accuse a person 302 holding that it's a case of suicide, you cannot straight away convict him under section 306 of the
Exactly.
IP, because the charges are completely different. So you will be definitely prejudiced. So that must be alternative charge. And obviously in a 302 case, you cannot frame charge under 306 because it is completely contradictory to each other. So everything is to be done at the first instance. So here is a case of suicide, the other is a case of homicide, completely different. So 304B, it's all right. 302, 304B and 304B charge is framed, you can convict him under section 306 because if the other ingredients are not made out, dowry, etc., not made out, so that there is no problem. So but 302 is totally different from 306.
ମୋ କହିବା କଥା କଣ କି ପ୍ରପର ଚାର୍ଜଟା ହେଇଥାନ୍ତା 306 ରେ 302 କୁ ଯାଇ ନଥାନ୍ତେ। ସେଇଟା ହଉଛି application of the mind.
So that is perhaps the postmortem report should have been seen carefully, examined by the public prosecutor, should have been brought to the notice of the court. When the doctor says like this, how can you frame a charge under 302 of the Indian Penal? All right. Yes.
Item number 5.
Yes, Mr.
It's the missing report filed by the daughter that his father is.
No, it came for the last time on 26 to 2021. ତାପରେ ଆଉ ଆସିନି ଦେଖିଲେ 26/2/2021 पर ଆଉ लिस्ट ହେଇନି नहीं. So anybody was suspected on anything like that?
That instruction I couldn't get, Mala. Let it be taken up tomorrow. I would take.
No, the FIR was registered or not?
No. Missing report.
It's a missing report given. So
there is a affidavit by the IAC 2021.
What he has been stated that
He has annexed the statement of some witnesses in it.
He recorded some witnesses and
just take the instruction. If it is a case of missing person, obviously the writ would be disposed of in view of the observation made by the Honorable Supreme Court. This court has also held. If it is a case of simple missing person, but if you have found out in the meantime something, and we'll take up this matter tomorrow, as you say. All right, it will be taken. I carried a cue.
Item number 6.
May please, Your Lordship. Last occasion, Madam, direct to produce the status report.
Charge of investigation by the as for the investigation present in court and submitted started taken sincere steps to rescue the victim but failed to do so. She had also contacted cyber cell from times tracking the record movement, but mission could also stated several steps have been taken to rescue the victim and to obtain suspect Nila Corridor. But in spite of so and so, okay. After going to the status report, we are not satisfied with the manner in which the investigation has been carried out. Even though she has taken over the charge of the last 3 weeks, the investigation requires the adjournment committed. She will produce the case diary. Detailed steps on for the rescue. Noted that the victim girl was a minor daughter of the child was about 14 years of age. And 2.5 years have elapsed since the date of registration of the FIR, and being unsatisfied with the status report furnished by Swanso, we have directed the SP to appoint police officer in the rank of DCP to investigate and carry out detailed investigation. Even we hope and trust that the investigating officer appointed by the SP Javasimpur has been. Okay. Yes, sir. So, what is your development?
So far, the development is that only development that got information that the last parameter that in 23 and 24th he has called his one of the sister Miller. So accordingly, we have
Who called the sister?
the accused Miller contacted the sister Miller, elder sister. And so we have collected the numbers of the married sisters Miller, and also TDR numbers are all for Miller. So little bit time.
No, that very phone which he was using, from that phone he made a contact.
Different phone, Miller.
Different phone.
So we are just having the numbers of the sisters Miller. So we are tracking that.
No, এই নম্বর যদি 24/11 মনে হয় রিসেন্টলি। আচ্ছা। And the other part about the bank transaction,
there is no transaction till 2011, 2021.
So these sisters, etc., they were living in this vicinity of the, or they are living at different places in different state. ତାଙ୍କୁ ଏକ୍ସାମିନ୍ ହେଲାଣି?
ନାଇଁ ଏକ୍ସାମିନ୍ ହେଇନାହାନ୍ତି। So because the
ମାଇକ୍ ପାଖକୁ ଆସନ୍ତୁ। କଣ କରିଛନ୍ତି? ଏଇ ଯୋଉ 24/11 ଆପଣ ଯୋଉ ପାଇଲେ ଲେଖିଛନ୍ତି ଲାଷ୍ଟ ପାରାଗ୍ରାଫ କୁ ଆସନ୍ତୁ।
sir.
Have you given a copy to him? Give him a copy. Achha, all right. Come to the last paragraph.
Sure.
On 24, please read it out and explain to us, sir.
On 24/11/2023, received information from sources that accused have contacted with his elder sister and younger sister over telephone on 23rd/11/2023 and 24/11. Hence collected the phone numbers of Satyabhama Parida, mobile number
Married elder sister.
married sir, and one unmarried sister. There is a Itishri Parida and Daitari Das. We visited the accused home, sir, and examined Itishri Parida and his parent also, sir. And we paid our SP for CDR, all these numbers, sir.
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ ନମ୍ବର ଗୁଡାକ ଦେଇଛନ୍ତି ଏଗୁଡାକ ତ ହଉଛି ତାଙ୍କ ଭଉଣୀ ଭିଣେଇଙ୍କ ନମ୍ବର।
Sir,
ଆକ୍ୟୁଜ୍ଡ ନମ୍ବର ଯୋଉ
Accused
ପର୍ଟିକୁଲାର ନମ୍ବରକୁ ଆସିଥିଲା ବୋଲି ଫୋନ କହୁଛନ୍ତି ସେ ନମ୍ବର ଆପଣ କୋଉଠୁ ପାଇଲେ?
ନାଇଁ ସାର୍ ଆମେ ସାର୍ ସସ୍ପେକ୍ଟ କରୁଛୁ ଇନଫର୍ମେସନ ପାଇଲୁ ଯେ ସେ ଆକ୍ୟୁଜ ଏମାନଙ୍କ ସହିତ କଥାବାର୍ତ୍ତା ହଉଛି ତ ସେ ନମ୍ବରଟା ଆମେ ପାଇନୁ ଆକ୍ୟୁଜର ସାର୍ ଏମାନଙ୍କ ନମ୍ବର ସେଥିପାଇଁ ଆମେ ସିଡିଆର ପକେଇଛୁ ଯେ ୟାଙ୍କ ନମ୍ବରକୁ କୋଉଠି ବାହାରୁ ନମ୍ବର କଲ୍ ଆସିଛି କି କିଛି ସସ୍ପେକ୍ଟ ନମ୍ବର ଆସିଛି ତ ଏମାନଙ୍କର ସିଡିଆର ଆସିଲେ ଆମେ ସାର୍ ତାକୁ ଏକ୍ସାମାଇନ କରିକି
So query was that whether these sisters are staying in the vicinity of the village
yes
or
yes
they are staying
unmarried sister is staying in his home sir.
So have you
Accused.
contacted that sister?
Yes yes sir.
Where is this statement?
ଆପଣ ଯେତେବେଳେ ଏମିତି ଗୋଟେ ଖବର ପାଇଲେ କିଏ ଆପଣଙ୍କୁ ଖବର ଦେଲା ଯେ ଆକ୍ୟୁଜ ତା ସାନ ଭଉଣୀ ସହିତ ତା ବଡ ଭଉଣୀ ସହିତ?
ସାର୍ ଏଇଟା ସସ୍ପେକ୍ଟେଡ ଆମେ ଲୋକାଲି ଇନଫର୍ମେସନ ପାଇଲୁ ଯେ
ଏ କଥା ତ ହେବେ ଏକ୍ସ ଆଣ୍ଡ ୱାଇ ଭିତରେ
ସାର୍
ଏ ସବୁ କଥା ଚୁପଚାପ ହେଇକିନି କଥାବାର୍ତ୍ତା ନା ଆସିକିନି ରାସ୍ତାରେ ସମସ୍ତଙ୍କ ସାମ୍ନାରେ କଥାବାର୍ତ୍ତା ହେବେ when the case is pending against that man the sister will come out in the open on the road and contact his brother or talk to his brother openly so that others can know and intimate the police about the same.
No, sir.
କାହାଠୁ ଖବର ପାଇଲେ ଆପଣ?
Sir, locally they are saying that the accused is contacting with the family.
ଲୋକାଲିଟି ମାନେ କଣ? ଆମେ ଲୋକାଲିଟି ଇଜ ଏ ଭେରି ବ୍ରଡ ଥିଙ୍ଗ। ଆପଣ କାହାଠୁ ଖବର ପାଇଲେ? କାହାଠୁ ଖବର ପାଇଲେ ଯେ ଆକ୍ୟୁଜ୍ଡ ଆଉ ତା ଭଉଣୀ ଭିତରେ କଥାବାର୍ତ୍ତା ହେଇଛି ଏ କଥା କିଏ ଦେଲା ଆପଣଙ୍କୁ ଖବର? ଯିଏ ଖବର ଦେଲା ସେ କେମିତି ଜାଣିଲା ସେ ତାଙ୍କ ଭିତରେ କଥାବାର୍ତ୍ତା ହଉଛନ୍ତି?
Sir, the information was not concrete, sir. So we made.
ଆପଣ ଏଠି you have given a report before this court. You have given a report before this court. Have you stated falsehood?
Sir,
Then
sir,
how do you came to know? ଜାନାଇ ତାହେଲେ ଇଏ କରି ଦେଇଦେବେ। ଆମେ ପଚାରୁଛୁ ଆପଣଙ୍କୁ। You are now in the dock. I'm asking you that who told you? We are asking you. Who told you that the accused has contacted with the brother or sister or the brother-in-law? How do we came to know? And on what basis? What is your rank? You are a DSP, na?
No, madam.
Yes,
No,
sir.
he's madam.
No, you see, he has mentioned that he has collected the phone numbers. Where from you
May I
collected?
say one thing, madam? Because the DSP who is the investigating matters, he is one of the staff of the DSP, madam. Because due to the last day presidential duty, he could not come today. Let it be day after tomorrow or tomorrow.
Sir,
I know.
14 years, girl.
Yes, madam.
She's missing since 2.5 years.
Because
and this side of investigation, we dissatisfied. We asked the SP to engage somebody, higher police official. So DCP or DSP was engaged. We expressed that we are not satisfied with the manner in which, and this is the way statements are being made, produced before the court.
No, a simple excuse that no further investigation has been conducted is all right. But having stated that we have conducted investigation,
right, madam.
Do they want the court to be befooled? We can't know. These phone numbers you have collected from whom? Right now you said that you examined. Have you come with the statement of these witnesses? Where is that?
ଜଣେ ଲୋକ ଯେତେବେଳେ ଜଣେ
statement record ହେଇଛି?
No sir, house search.
କାହାର house search ହେଲା?
Accused, sir.
And what about the sisters with whom he contacted? House search is not important right now.
ଜଣେ ଅନ୍ୟ ଜଣଙ୍କ ସହିତ ଫୋନ ରେ କଥାବାର୍ତ୍ତା ହବ ଜଣେ କେମିତି ଜାଣିବ ଆଇଦର ସିଡିଆର ରେ ଜଣା ପଡିବ ନଚେତ ଯିଏ ଯଦି କିଏ ପାଖରେ ଥିବ ସେଇ ଲୋକ ଜାଣିବେ ତେଣୁ ଆପଣ କୋଉ ସୋର୍ସ ରୁ ଇନଫରମେସନ ପାଇଲେ ଯେ ଆକ୍ୟୁଜ ତା ଭଉଣୀ ଭେଣେଇ ଏମାନଙ୍କ ସହିତ କଥାବାର୍ତ୍ତା ହଉଛି ହଁ and we put a question to you that it is not expected that the sister would talk openly in front of others when a case is pending against him for kidnapping a minor girl.
Let it be day after tomorrow. Let the DSP may appear and because the report is submitted by the DSP.
এটা ରଖି ଦେଇଥାନ୍ତୁ ପହର ଦିନକୁ ଏଟା ଡାକିବେ
Item number 7.
May I please?
just a minute last order is 13/11/2023
Yes, my lord.
Council the IAC Khandapada police station has filed the written report so answer to the effect that opposite party number 1 husband of the petitioner has not arranged any rented house till so and so opposite party number 1 was contacted he did not show the rented house which he stated to have had for the petitioner for which the petitioner did not come to reside there. It is further mentioned that the police time and again contacted the opposite party number 1 and asked him to obey the order of the court dated 8/9/2023 and to show the rented house which he stated to have taken for his wife, but he remained silent. It is further mentioned that the mobile phone of the opposite party number 1 is remaining switched off. The written report is taken on record. After going through the report furnished by the IAC Khandapada police station, we find that the statement made by the opposite party number 1 being present in this court on 8/9/23 that he had already arranged a rented house in Khandapada to stay with the petitioner and their son, and that intimation has also been given to the petitioner in that respect, but she did not turn up over and is nothing but falsehood. The IAC Khandapada police station shall make all necessary steps for arresting the opposite party number 1 and produce him before this court on the next date, and the minor son of the petitioner on the opposite party shall be rescued from the custody of the opposite party number 1 and be produced before the Child Welfare Committee. We shall keep the child in safe custody till the next date. So in the meantime, the opposite party number 1 arrested land council for the state after coming to know about the same can make a mention before this court so that the matter can be listed earlier. Yes. What has happened?
We have complied that we have arrested and bring him.
Where is it?
I have instruction to appear for him.
Yes.
Wait.
Wait. केबे डेट ହେଇଥିଲା 8/9/2023 pursuant to the order dated the opposite party number 1 Satyanarayan Maharana is present in court in person and is submitted that he is a carpenter by profession and his minor son is staying with him. He further submitted that as per the order dated so and so passed in so and so he arranged a rented house in Khandapada to stay with the petitioner and their son. An intimation has also been given the petitioner in that respect, but she did not turn up. Further submitted and petitioner did not turn up. Petitioner did not stay with him. He has not paid ₹3,000 and other expenses as per the aforesaid order dated one. And counsel for the petitioner, on the other hand, placed a letter written by the petitioner to the opposite party number 1 expressing her desire to stay with him, which is annexed to so and so. The opposite party number 1 also submitted that he has received the letter sent by the petitioner on such and such day. Since it is stated by the opposite party number 1 that he has taken a house on rent at Khandapada, let the inspector in charge of Khandapada police station visit the rented house in question with the opposite party number 1 and see the condition of the house, and also make necessary inquiry from the landlord as to whether the opposite party number 1 has taken the house on rent or not. After verification of the house, if everything is found to be in order, intimation shall be given by the inspector in charge Khandapada police station to the petitioner, and the opposite party number 1 shall himself go and bring the petitioner to the rented house in question, where both of them will stay with their son. The court expects both the petitioner and the opposite parties with their son to leave together peacefully and happily. The inspector in charge of Khandapada police station shall send a lady police officer to visit the rented house within a short gaps to ascertain the well-being of the petitioner during her stay with the opposite party number 1 and their child. The inspector in charge shall submit a report to this court to the Land and State Council by the next day. If any untoward incident is reported or complaint is made by either of the parties, the inspector in charge shall take care of the same in accordance with law. Shall intimate the order to the petitioner so that the petitioner will follow the order and accompany the opposite party after getting due intimation from so and so. आगु माइक पाखु आस ना कौन
सत्यनारायण महाराज
कोर्ट रे जते बड़े हाजर हेतिलो 8/9/2023 रे मन अछि कोन कहितिलो
घर भड़ा नबा
कोन कहितिलो
घर भड़ा नबा
तो माइक टाउटी एडजस्ट कलो कोन कहितिलो
घर भड़ा नबा पे
घर भड़ा नबा पई कहितिलो ना कहितिलो घर भड़ा ऑलरेडी मु ठीक कर देइची
हां आज्ञा ठीक
आउ मु खबर देइची मो स्त्री को आसिकिन रहिया पई से आसुनांती आ जेतु से आसिकिन मो पाखरे होचंती मु आउ सेइत पई जो खोराक पोसाक पई जो कुआइतला 3000 टका दवा पु मु देइनी ए आप कहि किन जाइतला ना आउ तमे सेइथि पई पुलिस को कुआला जे तमे को घर कहार नेइचो तांकु देखिबा को से विजिट करिवे देखिबे से घर अवस्था केमती अछि तो
नहीं चल रेडी सार मु कहितली सार कहले मत नाही आपन को
सार तापर रिपोर्ट करले
देखा को पे कहितले आज्ञा
सार तापर रिपोर्ट करले जे सिए तमे को कोनोसी घर देखै पारलनी एवं तमु जेतबेले जोगाजोग करेले जे को घर तमे भड़ार नैचो कहा घर भड़ार नैचो देखाओ कारण कोर्ट रो निर्देश अनुसार सी जाइकिन देखि थांते से घर मालिक संगे कथावार्ता करथांते तमे तांकु देखै पारलनी तेणु एथ्रु से कहउछंती जे तमे कोनोसी घर भड़ा नेइना का घर भड़ा नेइथिलो
आज्ञा इते
कागज कोन से तो देखिले आ
घर भड़ा नहीं
नाही आ
कागज कोन आउडा कागज नै आसी पुनी आउडा मिछ कहइबो कोर्ट
ना ना
हां
नो नो
पुलिस बाबू जेतेबेले कहिले कहा घर भड़ा नेइचो देखाओ
कहि प्रफुल्ल कुमार साहू घर भड़ा
के
नहीं
के जाइथिला कोन कोन कहले सी
घर चाल देखिबो कोठी
हां
घर नेइचो देखला परे तापरे
हां से तो को ऑर्डर हेइथिला कोन कहले
से तांकर
कोन गुटा कागज आनी देखुजन
से तांकर ड्यूटी पड़थिला परे से राति 8 रे चली गले कहले सकाळु आसी कि
को
मते
किए से प्रफुल्ल साहब कोटिया लोक
फनपड़ा आज्ञा घर भड़ा जोटे मु नहीं
पुलिस को कहलोनी कोन पई
कुआ आइतला आज्ञा मैं कॉपी नहीं कि सार देखैतले मु कहले सार घर भड़ा नहीं प्रफुल्ल कुमार साहू घर भड़ा नहीं आ आपण इनगारी ऊपर को जिबा पे सार कहले मोर ड्यूटी
केते टका धार्य होइछ
आज्ञा 2000 टका लेखा
पैसा देलोनी
पैसा तांको ऑलरेडी दिया है 2000 टका
हां
2000 टका दिया है
चाबी नहीं न
आज्ञा चाबी अछि मो
अछि तो घर तमे देखि पाथन तो प्रॉब्लम पई का पे कल
ना ना आज्ञा सी तांको घरटा मु नेइथिली सार कहले का घर नेइछु प्रफुल्ल कुमार साहू घर
तुमको घर देखिबा ले कहैतला तमे कहले जे प्रफुल्ल वर्तमान जाइतले ड्यूटी पळेला देखि पालेनी काहे की
आज्ञा
चाबी तो तम पाखे तला देखि तांतो
तम
सार पर
कोर्ट ऑर्डर हेछि जे तमे पुलिस बाबू को घर देखैबो पुलिस सब देखिबे ठीक ठाक अछि ना नहीं तापर से खबर देले माने तापर तमे जाईकी निजे नेकी आसीबो तमे तो घर ठीक करथलो चाबी तो तम पाखरे एग्रीमेंट हेछि जदी कहउछो तुमे एग्रीमेंट हां तेणु असुविधा कौन है कहीं पुलिस को देखेलनी कौन
सार ड्यूटी पड़े सार सकाळ मते कहले सकाळु आसीकी मते घर देखिया पे सकाळु मते कहितले सार
तुम सामने रे कहउछंदी पुरा
सर घर देखैनी सर फिजिकल न देखले मु कोन करिवि
आज्ञा सर
देखले मु ताको कहली तू चल देखिबो
से ही ऑर्डर हेतला जहा कहउछंदी पुलिस ऑफिसर जहाँ कहउछन सेटा ठीक जे निजे जाई देखिबार ऑर्डर है
आज्ञा
तो वर्तमान कौन तमे चाहूछ
नहीं मु चाहूँ मो वाइफ की रखा चाहूँ ना
से देखी से कौन से एग्रीमेंट कौन से ए स्टाम्प पेपर टा को दिन किनलो
आज्ञा एठू जो जिबा पर मु करा हिचे आज्ञा
से घरे रहउछ
आज्ञा
केत सप्ताह तले 3-4 दिन तले किनिछ एटा
डेट नहीं कि
आउ
डेट हिचे आज्ञा
अरे काटू किनिछ एटा
आज्ञा
काटू किनिछ
किणा ही आज्ञा एटा हम को ये रे करा हितला आज्ञा हमरो
को दिन करे सप्ताह ना 1.5 सप्ताह 2 सप्ताह को दिन कहूनु
29 न आज्ञा हितला 29 न ता चुक्ति पत्र हम रहतला
एटा 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 स्टाम्प पेपर लिखा हिची ए जो एग्रीमेंट पेपर किना जाए केबे किनिछ स्टाम्प पेपर ना एटा प्रथम जालिया कि तू आनी प्रोड्यूस कर एटी लिखा जाए काहाकू बिक्री होउची को दिन बिक्री हला एटी दस्तखत रहे ना तार दस्तखत अछि ना एटी लिखा आइछि चौद्वार जेल को अबिका जीव मिछ साक्षी दउछ कोर्ट रे आनिकिनी ये लोक तुमको ये देइनी एड़ा बिकिनी बिकिले बेले कौनसी एग्रीमेंट पेपर तार कागज रे लिखा जाए ता डायरी गोटे रजिस्टर मेंटेन हुए रजिस्टर मेंटेन रे रजिस्टर भी लिखा जाए को दिन को एड़ा जानिथिले सिना हबो मिछ कहया को चेष्टा कले गोटे पर गोटे मिछ कहइबो नाउ यू आर टेलिंग falsehood before the court and you are liable for contempt of court अदालत रे मिछ बयान दउछ वर्तमान तमे भीतर को जीवो ए जालियाती कागज या देरे किछि लेखा आइनी किए बिकिला तुमको को दिन बिकिला हैला एगुडा को लेखा हुए एडी से दस्तखत करे स्टाम्प वेंडर एवं तार रजिस्टर मेंटेन हुए सेटा प्रमाण दिए जे बिक्री हेइतला किछि नाही आदेर हु टोल्ड यू किए तुमको कहला ए भलिया कागज आनी दबा पई एठी प्रोड्यूस करे एमतिया कागज आनी किनी दबाव किए कहला तुमको
घर मालिक
हां
घर मालिक कहला कागज गोटे कोर्ट नै कि आसी कि अंडर लिखि दे कि सिग्नेचर
से स्टाम्प वेंडर करिकिन रखितला ताडू नै आई लगी से तुमको तो चोरी केस रे पकेबा आगे से गुडा को बोधे रखितला कारण से कागज यदि बिकी थांदा ते पचे उल्लेख करी बिकी थांदा कि केबेले ता रजिस्टर लिखा ही नथिबो कारण से तो निजे लिखिनी ना
Madam, we are repenting.
I am.
Mr.
Have you
Tripathi.
seen this conduct of this one? This is a telling falsehood. Nothing is there in.
I have not gone through any documents. He has telephone.
आप काली तैयारी करी आनथिबो ता कोठू हम उठे कि नहीं आस्थिबो एटा तार ए घरु नहीं आस्थिबो कोन को से जान नथिबो से लोक जानथिले से केबे देई न थांदा भारी चालाकी लोक ये
Yesterday he has produced before the CWC.
खेलिबाकू चेष्टा कले चौद्वार होची तमरो शेष रास्ता वर्तमान कौन चाहूच स्त्री की नहीं रखिबो ठीक करछो जागा हां एटा रख एटा गोटे मिछ देइछि एटा रखि त केस को पेंडिंग कर रख ताकू से जो घर लोक नहीं छंती आपण आज से जीव आपण को नहीं किनी से घर देखंतु ठीक हेले से लोक को परिछि ना नहीं देखंतु देन विल पास द नेसेसरी ऑर्डर आमे मैटर टाकू पहर दिन रखुछु हला आपण ताकू धरि किन आसीबे पहर दिन या ता स्त्री अछंती डाकुन
And ensure that he is staying there. Unless he is staying in that house, how can he bring the wife? He must ensure that he is staying in there.
जेरस करी दियो हला जेरस कर दियो से स्टाम्प वेंडर पाकू जीवो एग्जामिन करिवो हला स्टाम्प वेंडर ना लिखाई शरद कुमार मिश्र कब ये लोक को बिकी थलो ये जो प्रफुल्ल कुमार साहू के स्टाम्प बिकी थलो देखियो हां फिजिकली कोनोसी घर देखेला नहीं से देखियो परा कोई आजी नहीं किन देखिबो डे आफ्टर टुमोर रहउचे ता भितरे एतियो करी किन आनिथिबे पहर दिन हला एटा जाली
document टा भी ताकू देतंतु so that
ना एटा मु जेरॉक्स करी दउची ओरिजिनल
हाँ।
एटी रहिला कोर्ट रे
He got the photocopy problem. Mr. Tripathi, you are going through that, no?
My lord,
It's a photocopy.
my lord.
It's on there.
No, back
Ah.
side, my lord, I have.
हां
no-
बैक साइड मु देई दउची
हाँ।
बैक साइड टा करी दियो कोन आपण स्वामी को पाखर जाई रहिबाकू चाहुचंती हां
ରହିବାକୁ ବର୍ତ୍ତମାନ ଚାହୁଁନି ସେ କିଛି କରୁନାହାନ୍ତି ସେ ଗଞ୍ଜେଇ ମଦ ଖାଉଛନ୍ତି ଏବେ ବି ସୁଦ୍ଧା କିଛି କରୁନାହାନ୍ତି କେବଳ ସବୁଠି ଭଦ୍ରଲୋକ ମାନିଲେନି ଥାନାକୁ ମାନିଲେନି ନୟାଗଡ଼ କୋର୍ଟକୁ ବି ମାନିଲେନି
आपण जेतेबेले गत थर नहीं ता पूर्व थर केस उठीथिला आपणकर एडवोकेट गोटे चिट्ठी आनी देइथिले कोर्ट रे प्रोड्यूस करथिले जोथिरे आपण लेखिथिले जे मु जाई रहिबाकू चाहूची तो एई जो सबु तापरे आपण जेहेतु रहिबाकू चाहूचंदी सीए मध्य कहले जे मु घर भड़ा नेकिनी ये करछि सेति पई कोर्ट एई सब ऑर्डर गोटे पर गोटे पास करछंदी तो आपण जदि राजी न हबे तले लाभटा कोन आपनको तो बाध्य करा जाई परिबनी आपनको स्वामी को पाखे रहिबा
ଛାଡି ନାହାନ୍ତି
हां
ମଦ ଗଞ୍ଜେଇ ବି ଛାଡି ନାହାନ୍ତି ଫୋନ କରିକି ପଚାରିଥିଲେ ନା ତୁ କଣ ପଇସା ଦଉଛୁ ମତେ
नहीं से आपण वर्तमान आपण जहा एडवोकेट कहिथिले लास्ट डेट रे 8/9/2023 रे सेतेबेले आपणकर चिट्ठी द्वारा हमकु जणैथिले जे आपण निजे जाईकिनी रहिबाकू चाहूचंती हला तो वर्तमान आपण मत परिवर्तन कर सारलेनी आ रहिबाकू चाहूनांती ना चाहिबे कोन ठीक से कहंतु
ସେଟା ଭୟ ଲାଗୁଛି ତାଙ୍କ ପାଖରେ
हां
ଭୟ ଲାଗୁଛି ତାଙ୍କ ପାଖରେ ରହିବାକୁ ସଂସାର କରିଛି ଯେତେବେଳେ ରହିବି ନିଶ୍ଚୟ କିନ୍ତୁ ଆମ ସାର୍ କେହି ନାହାନ୍ତି ତାଙ୍କ ପରିବାରକୁ ଶାଶୁ ଶ୍ୱଶୁର ବି ବହୁତ ଦୁଷ୍ଟ
आमे केस टाकू रखुचु बुधवार दिन को आपण आउटे चिंता करंतु तांको कुहाइची से जाईकिन से भड़ा घरिका जोठी नेइचंती से पुलिस बाबू देखिबे से सब विषय रे अनुसंधान करिवे आगुरु मध्य ऑर्डर पास हेइथिला जेतेबेले जदि आपण एकाठी भी रही थांते कोन जने लेडी पुलिस ऑफिसर जाई थांते आपण देखा माने मझिरे मझिरे जाई थांते एवं आपण को विषय रे पचारि थांते आपण को पचारि थांते जे ठीक ठाक अछि ना नाही कोनोसी असुविधा देखेले संगे संग कार्यानुष्ठान हेइथेबे बोली मध्य ऑर्डर हेइछि तेणु आपण जो कहउचंती ना असुरक्षित अन्यान्य जिंस सेति पई कोर्ट ऑलरेडी ऑर्डर करि सारिचंती हला तेणु से विषय रे भय करिवार किछि नाही किंतु आपण को बाध्य बाधक करा जाई परिबनी आपण भविष्यत को चिंता करिवे आपण पिलाटी अछि हला ए सब जिंस को चिंता करी आपण को आमे समय दउचु पहर दिन आपण आसंतु या भितरे से जाईकिनी देखंतु सो
My lord, it may be taken out Friday because he has evidence to in the Kendrapada court. He has to go there.
Okay.
Evidence
Friday
Friday. One thing is there more that if person is not staying in the locality after a long year, he has arrested him. ଆଜି ତାକୁ ଆରେଷ୍ଟ ଦେଖେଇଛନ୍ତି ତାକୁ ତ ଫ୍ରାଇଡେ ପର୍ଯ୍ୟନ୍ତ ତାକୁ ଗୋଟେ କଷ୍ଟଡି ନ ରଖିଲେ ପୁଣି ସେ ଆଉଥରେ ଆପିଲ କରିବ ନାହିଁ ଡାଉଟ୍
no taku PR bond re ye korantu but he has to give the PR bond for appearance before this court on the date fixed we fix it on 1st 11 but in the meantime we are passing the order to show the that particular house to this one all those things are to do
locality ତା ମା ବାପା ପିଲାଟି ରହୁଛନ୍ତି but he is not doing that
PR bond ରେ ତାକୁ ଛାଡନ୍ତୁ ସେ ତାକୁ PR bond ରେ ଆଜି ଇଏ କରନ୍ତୁ ହେଲା ताकू एवं से 1 तारिख दिन से PR बॉन्ड रे लिखिथिबे 1 तारिख दिन से आसीओ बोली तो दियन सेटा दिन जीवो
where he is working as carpenter on his own or no किछि नहीं
Not fixed. Not fixed place.
जो जे राखिला से जाय काम এটা স্টাফটার মারি কি বাবু କୁକୁର ଆଦମି ସେଇଠି ପହଞ୍ଚି ଗୋଟେ ପଳେଇଥିବ ବୁଝିବ লেখুন in persons of the order dated 13/11/2023. You are the IIC?
Sir.
Please give your name. So and so the inspector in charge of Khanpada police station. Produce the opposite party number 1. Opposite party number?
1.
Opposite party number 1 to the state of Orissa. Opposite party and
2.
1. Acha acha.
1 is the
अब एटी कौन लिखा है जी पेपर
Petition WPCR.
WPCR.
Opposite party number 1.
Okay.
Opposite party number 1.
ठीक है. Opposite party number 1 before this court. Sure. On query made by the court, the opposite party number 1 intimated that he had already arranged a rented house in Khondapada to stay with the petitioner and their son. And he had also apprised this to the inspector in charge of Khondapada police station. When this court asked for any documentary proof regarding taking of rent of any house at Khanpada, the opposite party number 1 produced an agreement before this court in which he was is the first party and the second party is one Satyanaran Maharana, son of Suresh Maharana, village post PS Khandapada, ward number 7, Nayaga. And the date of execution of the agreement has been mentioned to be 29/9/2023. The opposite party number 1 further stated that he is having the keys of the room with him now. The IIC stated that even though he asked the opposite party number 1 to show the house so that he will visit and make necessary verification as per the order of this court dated 8/9/2023. But the opposite party number 1 didn't show the rented house to him, which is stated to have hired for the petitioner. The agreement paper which was produced the Sarat Kumar Mishra of Khandapada, but neither any no endorsement has been made by the concerned stamp vendor who have sold the agreement paper to the opposite party number 1, nor his signature is appearing in the back of the stamp paper. We create doubt about the authenticity of the execution of this document. A copy of the agreement paper produced before us is handed over to the IIC, Khanpada Police Station, in court today, who shall make necessary inquiry to ascertain as to whether the said Sarat Kumar Mishra has sold the stamp paper to the opposite party number 1 or not, and if so, on what date, and whether there is any endorsement made in the register of the stamp vendor to that effect, and why he has omitted to make endorsement in the back of the stamp paper regarding selling the same to the opposite party number one. Since the opposite party number one has stated that he has taken a house on rent, the IIC shall visit the house in the company of the opposite party number one and comply the order dated (31), no? Moment, 3110. Seven. 7 is 20 of 23. Comply the order dated the previous order. 8/9/2023. Since, as per the order of this court dated 13/11/2023, the IIC has already arrested the opposite party number one and produced him before this court. The opposite party number one shall be released on PR bond with condition that he shall appear before this court on 1st of December 2023 at 10:30 a.m. and shall cooperate with the inquiry to be conducted by the IIC. Stop. The petitioner is present with her learning counsel, and she shall also present on the date fixed. Free copy of the order be handed over to the learning counsel for the state. So, one more thing, my lord. The child was produced before the CW. Now the child is in the custody of the parents
Husband.
of the number one.
Child was produced, sir.
Produced before the
CWC.
CWC. Acha. Now he is in custody. He is in the parents of the number one. ठीक है. से था बर्तन. पुअर तो पुअर. अच्छा. It is stated. It is stated that as per the last order dated, that is 13/11/2023, the child of the petitioner and the opposite party number one was rescued from the custody of the opposite party number one and was produced before the Child Welfare Committee, and on 26/11/2023, and the child has been handed over to the grandparents, with the father and mother of the opposite party number one. Let the child stay in the company of his grandparents till next date. So you are clear what you are to do.
Sir.
You will make necessary investigation, make a query to this person, whether it has been properly sold or not, whether it is a fake document or not. Okay. And number two, he has got the keys of that room. So contact that landlord, ask him that when he has taken the house on rent, okay, and see the surroundings and whether it is a inhabitable condition or not, all these things. And aji apono taku bond re ye karibe, so that take proper bond that he will ensure come here on fast and also cooperate with you. Okay, it is up to you how you will manage things. Apono आज कोर्ट रे ए जो कागज तमे आनी प्रोड्यूस कल कोर्ट रो वर्तमान संदेह उपजिची तेणु थाना ऑफिसर को कहला या विषय इनक्वारी करिवे। नंबर 2 से घर जो चाबी तम पाखे अच्छी बा जो भड़ा नहीं थाना बाबू को लेकिन से घर देखो से सब कोर्ट रो ऑर्डर अनुଯାयी ताको वेरीफाई करिवे सब ठीक ठाक अच्छी ना नहीं। तापरे 1 तारीख दिन आसी तमे एठी हाजर हबो 10:30 रे हला एई विषय बॉन्ड देकी नि जीवो पर्सनल बॉन्ड देकी जीवो। आपण को कहा गला जे ए केस रो नेक्स्ट तारीख धार्य हला 1 तारीख दिन आपण आसिकिन उपस्थित रहिबे हला ठीक है एटा रखि दो द डॉक्यूमेंट इज टेकन ऑन रिकॉर्ड।
Item 8.
Let's see, last order date at 31/10/23.
Yeah.
You had taken over charge then recently.
Yes. Some more time may be granted for investigation and to visit different places and if possible to find out the other person. Okay. So, any progress made?
Progress some of the friends and the
No. आईओ आसी पारलांती ठीक अछि जे किंतु
report
यदि वो डायरेक्शन हेतला
हाँ।
यदि किछि
सीए
प्रॉब्लम अछि to solve.
frequently
But what the investigation you have made? Because the
Yeah.
order was almost a month has been
Aye.
passed in the meantime. 31/10 रे ऑर्डर पास हेतला सेते बेले आपनकर इन्वेस्टिगेटिंग ऑफिसर कहले मु रिसेंटली चार्ज नेइची तेणु गत काली नेइची बेली कहिथिले सेदिन एवं मते किछि अधिक समय दिया जाऊ मु इन्वेस्टिगेशन करिबी।
As per the report, Malas, he has contacted some of the relatives and also the friends and the classmates of the victim and the accused.
Minor girl.
Minor. Photographs with the collect kuchanti, analysis mein sita deichanti, but further fine. The chutri version will explain nahi. Dita case, aji agude case achi, same ayo. Here is the dita ko diya to janaho. Sette gote rescue kari chanti.
From your side, did you get any information, any whereabouts of your daughter?
No, ma'am.
So you want
Another time.
another date? What was the reason? Click on the land council for the petitioners, also the land council for the state is present. In pursuance of the order dated 31/10/2023, the land council for the state has produced the status report submitted by the Inspector of Police IUCAW, Balaswar, and submitted that even though an order was passed on 31/10/2023, directing the investigating officer to remain present, but she has got some personal problem and she's on leave. Therefore, she's unable to appear this court. From the status report furnished, it is found that the IU has visited the spot where the victim was last seen and contacted with the relatives of the accused as well as the victim parents and made a list of the classmates, friends, family members, acquaintance who might have got any clue and information about the missing girl. And she has also analyzed the CDR oblique SDR of the accused and the victim family members, collected photographs of the accused and the victim. The Learned Counsel for the state submitted that some further time be granted to the for apprising to this court about the development made in view of such submission. Place this matter in the week commencing from 18th of December 2023. The IO shall remain present with up-to-date case diary and furnish status report showing the progress made in the meantime. The status report is taken on record for the okay.
Item number 9.
May I please?
Yes, Mr. Panda.
My the minor girl is missing since 19/6/23. My
Photograph of the accused with the driver, Ejero Samso, has not been collected or by the statement made by the investigator. Collect the photograph of the accused, help him in tracing out the accused and victim if they are at all hiding at any places or in relatives' house after ascertaining the same from their locality. The investigating officers also the eyes paid and rescue the will be done in a serious manner to solve this also. So, any development made, Mr. No. What is the age of the girl?
date of birth is 11/11/2006.
6.
My lord.
So you want some further time?
My lord.
Have you got the status report which has been submitted today, Mr. Panda, by the Learned State Council?
Today's report I have not received, my lord. On 31st/10/2023.
So ask one of your associate to collect it. It is available with Mr. Das. Okay.
My lord. My lord.
So he has mentioned it various steps taken in the meantime for tracing out the victim as well as that accused. So he wants further time. So please collect the name and designation. So and so is present and file the status report, wherein the details of investigation carried out after the last date, that is 31/10/2023, has been mentioned. The investigating officer seeks some further time to carry forward his investigation. and to apprise this court on the next date about the development made. Copy of the status report has been furnished to the Land and Council for the petitioner. Put up this matter. Mr. Das, on 18th on 18th of December 2023, the IO shall remain present on the next date before this court with up-to-date instruction. It had taken on record for the 18 तारीख रे रहिला अपन कोन ता भीतर करिसेंती कोर्ट को अप्राइज करिवे आसी फ्री कॉपी ऑफ द ऑर्डर बी हैंडेड ओवर लंडन स्टेट काउंसिल. Yes.
Item number 10.
May I please? Last order, your lordship has observed on 8/9/2023
That's just a
that
minute.
the girl would attend the age of.
Just a minute.
Yes, ma'am.
तो से जगह तो पहुंची थिले जोठी माने काम करथिले दी जन जाको तापर सेठू पळेले कोडा आ गोटे यस एनी डेवलपमेंट मेट कोन आ भीतर करले दिए माइक यूज करो
सर सेठी जो जाइथलु से माने तांकर जो फोनटा आमे नेइथलु ट्रैकिंग सेटा रात्रि स्विच ऑफ रहतला तेणु ताको आमे दिन बेला जेमति आसिला डायरेक्ट जे आक्यूजर आसु नथला ई टाइप आसुतला माने पर्टिकुलर प्लेस आसुतला तार लिंक जे से ए टाइप आसुतला तेणु आमे दिन बेला बाध्य होई गलु अवश्य आमे सिविल थिलु किंतु से जो लोकल थाना नेइथलु जने स्टाफ से ड्रेस रे थिले हेले से तामिल तो आम भाषा बुझे ना जो गेट टा खोलिया पई कहिलु तेणु से बाध्य होई कि से तांको ड्रेस जे थिले तांको नेलु गेट पाखु सेतु लंच टाइम तांकर कंपनी जो काम करते इंडस्ट्रियल एरिया कोयम्बाटूर सर तेणु से आसुछन से खाया पई से विराट एरिया रे घर को सब ओडिया पिला बहुत पिला भी काम करछन सेठे तेणु से माने खबर पाई गले चेन माध्यम रे माने आरपट गेट रे जे पुलिस के आछन खोजछन बाबली बेरे गोल तेणु से पळेले पळे तमे आमे से जगह रहिलु से 6 दिन रहिलु कोयम्बाटूर रे से जगह छकी रहिलु निहाती घर को आसे जिनिस पत्र नवा पई बोली आउ किंतु से माने फेरले
नै आपण तो लिखि जंती ता डॉक्यूमेंट्स के रेजोन सीज
सर से जो घर रहउछन सेटा दि जणा डॉक्यूमेंट सीज कली तबर 6 दिन रही
एटा तो आपण को ए सब जिंस कहिथिले गत थर आपण कहिथिले 8/9/2023 रे
सर
तो आ भीतर प्राखा पाखी 2.5 मास हे गलानी आ भीतर कोन डेवलपमेंट हेछि हम कोन
डेवलपमेंट सर से जो मो फोन रा से बर्तमान व्यवहार करथला सेटा संपूर्ण स्विच ऑफ आ आईएमआई नंबर पर नुआ सिम से पके नांती आ जेति कि मु सेठा लोक पिला को रखिथिले हाथ रे कोयम्बाटूर से मानो सेठे रहु नांती से आगुरु केरल रे काम करथला सेठी कि से माने संभावना से माने कहउछन आज्ञा पळैछंदी आ माने से माने पाखा पाखी ताको देखु नांती बोली कहउछन मु 4 जण 5 जण ओडिया पिला स्पाई रखी सेठु आस्थिले
आरो डेट ऑफ बर्थ केते पूछंती
सर 18 प्लस हे गलानी
18 प्लस हे गलानी
30/10/2005
अच्छा एमानकर झियर बापा मांकर किछि आपत्ति अछि कि
नै एबे आउ सर किछि आपत्ति नै
माने पुओ को बा हेले मु कह
पुओ को बाहा पई से कास्ट नै कि तांकर आपत्ति सर अछि पुओ एससी माने जनरल त तेणु से
नै नै से तो अलगा कथा आपण जदी एमानकर आपत्ति नथिबो ताले कन्विंस जदी करैबे से विषय रे जदी अक्यूज्ड घर को ताले हुए तो से माने खबर देले जे वर्तमान से साबालिका हेलानी किछि असुविधा हबनी एवं यदि उभय पक्ष राजी हुअंती ताले रेस्क्यू होबाटा शीघ्र होई जिवो कारण हुए तो अक्यूज्ड भय करूथिबो जे वर्तमान गले मु तार कन्सिक्वेंस या हबो
से सर कहा कांटेक्ट जेतु हम थरे पहुंची गलु ସେ କାହା କଣ୍ଟ୍ରାକ୍ଟ ସିଏ ମାନେ
ଆକ୍ୟୁଜ୍ଡ ଘର ଲୋକ
ଘର
ତାଙ୍କର
ଲୋକ ତା ଫାଦର ମୋବାଇଲ ନାହିଁ। ଆଉ ଗୋଟେ ସାନ ଭାଇ ଯିଏ ସିଏ ଲଭ୍ ମ୍ୟାରେଜ କରିଛି, ସିଏ ଅଲଗା ରହୁଛି, ସିଏ ବି ଘର ସହିତ କଣ୍ଟାକ୍ଟ ତାର ନାହିଁ। ଆଉ ଝିଅ ତ କଣ୍ଟାକ୍ଟ କରୁନି ଆଉ କଣ। ତେଣୁ ଆଉ କାହା ସହିତ କଣ୍ଟାକ୍ଟ, ଗୋଟିଏ ମାଉସୀ ଘର ସେ ତା ପୁଅଟା ସହିତ କଣ୍ଟାକ୍ଟ ଥିଲା, ତାର ସେ ପକେଇଲୁ ଟ୍ରାକିଂ ରେ, ତା ସହିତ ବି କଣ୍ଟାକ୍ଟ ନାହିଁ। ସେ ପିଲା ପାଖକୁ ସାଗର ଭୋଇ ବୋଲି ତା ପାଖକୁ ଗଲି, ସେ ଗଲା ନାଇଁ ଆଜ୍ଞା ସେଇଦିନଠୁ ଆଉ ସେ କାହା ସହିତ କଣ୍ଟାକ୍ଟ ନାହିଁ। ସେ ତା ବାପା ବୋଉଙ୍କୁ ବି ରାଗିକି ଘରକୁ ଯାଇଥିଲା, ସେ ଆସୁନି ଘରକୁ। ସେ କାମ ସେ ପୁଅ ଯିଏ ନେଇଛି, ସେ ସେଇଦିନ ଆସିଛି, ଝିଅ ଆସିଛି ଘରକୁ କହିକି, ବଳଙ୍ଗାରୁ ସେମାନେ ପଳେଇଛନ୍ତି, ସେ ଘରୁ ବି ଯାଇନି ପୁଅ, ଟ୍ରାକିଂ ରୁ ଯାହା ଆସିଲା।
ତ ଆଉ ଗୋଟେ ଆଡଜନ କରୁଛୁ, ଆପଣ ଦେଖନ୍ତୁ ତା ଭିତରେ କଣ ଡେଭଲପମେଣ୍ଟ
ସାର୍
ପ୍ଲିଜ गिव योर नेम।
केदार चंद्र दुरा।
You are the OIC of Balanga police station?
नहीं सर,
अच्छा
सब इंस्पेक्टर।
in अच्छा लेकिन दियंतु अच्छी तो सेठी urgent sleep अछि। So and so is present and he has submitted the status report. We have gone through the status report. The investigating officer seeks some further time carry forward his investigation. In view of such submission, list this matter. It is second week of January 2024. Shall remain present with the up-to-date instruction. Pre-copy of the order be handed over to the Learning Council for the state. Status report I taken on record for the. So, Mr. Tripathi, second week roila January ro.
Item 11.
Same case to say you are.
In this case, my lord, as per my instruction, the girl has rescued.
Yes, rescued. All right, the Learning Council for the state has produced the written instruction received from the Inspector IUCAW Balasur dated 25/11/2023, from which it appears that the victim girl has already been rescued. Her statement has been recorded, and the girl is now staying at short stay home, sure, with the consent of the informant as well as the victim. Status report is taken on record. The in view of the no further order is required to be passed. The case is disposed of. Yes.
Item 12.
May I please, last time I directed the State Council prior to present a report to for this court.
Just a minute. Yes, any development?
Not yet rescued. We have.
You have submitted the status report. Give a copy to the Learning Council also. गत तारीख पर कौन करछन सेटा कोड लिखछन गत तारीख थिला 13/11/2023 तापर कौन स्टेप नहीं चंदी एवडा तो यूजुअली से प्रोसिक्यूशन केस अपन लिख दे हां
That was the first trace matter on 13th 11.
In course of investigation. ये तो गला से during local inquiry. Family members of the victim, fear psychosis, the accused person are not cooperating. Mobile number used by the accused so and so along with the others have been obtained, analyzed, but no effect. Phone switched off.
It was not a made copy.
I was also present, man.
Progress of investigation, let's see if I have a glance to this report. Progress of investigation, let's see if I have a glance to this report.
He has made that whatever he has done, stated such as he made accused person for all this. कौन करछंती आपण आ भितरे गत तारीख रे जो नोटिस इश्यू हला परे कौन इन्वेस्टिगेशन करछंती किछि स्टेप
जाई जे accused घर को जाई सर सर्च भी करछि ता घर सर
कहारो accused कौन ता घरे थांदा कियो
तारे ता अंकल जो अछंती अमरदारे ताको घर भी सर्च करि सर
रिलेशन मान घर को जाइछले सेठी की पाइलेनी को केतेटा रिलेशन दा
तार मामू घर केवल गोटे अछि
गोटे कोठी सेरा
अमरदारे सर
अच्छा सेठी की आसी नथिला ना टोटल ना जाइथिला पळेला
टोटल जाइछि आसिने
माने से मामू घर को जाइनी अच्छा बाकी अन्य किसी कांटेक्ट करूनी ता फैमिली मेंबर सहित
नंबर दिरा पाई सर आईएमआई सर्च देई सर पाइनी अब
किसी ट्राई आसीनी
सर
जियोरस
किछि नाही सर
जियो सांगो अन्यनो
ना सर के कोऑपरेट कोन
आपण तरफरु किछि पाइ नांदी
No, no.
What is the age now, by the way?
17 years, 13 days, my lord.
Okay.
But of course, the report of the police himself produced today for my lords.
No, no, your
आपण पर date of birth आपण भरती हो ना
No, no, date of birth is 18/6/2006.
Then it's
So it's 17 years.
17 years. So we are granting you some more time. So you carry forward your investigation and apprise this court on the next date about the development made in the meantime. कौन सब करिसेंती जानेबे. So and so the Natan is present and submitted the status report indicating the steps taken during course of investigation to trace out the victim, so also the accused. The status report is taken on record. Copy of the same has been furnished to the learned counsel for the petitioner. The IO seeks some more time to carry forward his investigation and to apprise this court about the development made. Please this matter January of the second week. It will take on record the key.
Item 13.
Yes.
Last occasion, Lordship directed to the learned districts send the report
to cause production of the minor daughter from the custody of some. And the matter was called on soon after going through the averments made in the acts to orally to ascertain about the correct state of today land council state has produced the written instruction received from the chairperson, from which it is revealed that the daughter of the petitioner has taken admission in a school, class 8, and she has expressed her unwillingness to go to her parents' house. How it is mentioned, Mr. Ansel child happy to hand over the child to the parent in the interest of the family restoration only to the satisfaction of the family. Okay. In the background in which the girl child was sent to the with a boy, and she allegedly got married to that boy and ultimately came to or parental house and was rescued by the child marriage prohibition officer. The presence of so-and-so, and I won't mention in the report. After going through the report, we think it proper to direct the Lieutenant District Cutter to depute a lady judicial officer either in the rank of so-and-so to the institution where the child is now staying to have an interaction with the child to see whether schooling, lodging, health facilities have been properly taken care of by the so-and-so. Said judicial officer shall also ascertain whether the child is willing to go to her parents and stay there with them. The report of the so-and-so shall be prepared. Okay. Copy of the so asira ki seal cover hai. June. खोलो. Parents mane iki mane the asi read petitioner. Who is the read petitioner?
My lord, the mother.
Mother. Okay. Native village Amarpura. Amarpura. You are for the petitioner.
My lord.
I see. So, Mr. Tripathi, the judicial officer in the rank of the ADJ, she visited the institution where the victim girl was staying and had an interaction with her. Now, the operative part of the order indicates that instruction which I report indicate that now the girl is interested to stay with her parents and to go to her native village. But since there is an allegation that they have given marriage to with a boy, and therefore we are not closing the case. We are directing that let the child now stay in the company of the petitioner, and we'll monitor for some time and see that okay, and we can take up this matter in the month of January, and this village now comes on which police?
Niyali
Police station,
PS.
Niyali
Niyali
police station.
My lord.
So Niyali ke posting judicial officer.
first class assistant to deputy judge.
Thank you. Please go ahead. तो ये लड़न JMFC Niyali after let us say he stayed there for 3 to 4 weeks, right, make a visit, and but in the meantime, if any complaint is made by from any source, the IIC of that Niyali.
Daughter-in-law is the Anganwadi worker, and they have a.
No, your daughter is now going to live in your company. Take proper care of her so that she will not have any complaint, because now as we find that she is being taken care of properly by the institution where she is staying now.
I pray, my lord, that should
Her
be
health,
monitored.
her education are all being taken care of. So now, since she has expressed her willingness to stay with you, you means the petitioner, the mother.
Yes,
So
ma'am.
take
Natural
proper
one.
care of her. Yes, natural. We don't
Yes.
say that. Take proper care, because the judicial officer is visiting her.
My
Will
lord.
visit her within 4 weeks and give a report. Okay.
But the villagers and my lord, the brother-in-law of the daughter-in-law is a Anganwadi worker. He is always against them because of the civil dispute. They will make a false allegation, and they have also made the allegation that he is the stepmother.
In persons of the order dated 8/11/2023, the London Session Judge Cuttack, London District Judge Cuttack entrusted the London Second Additional Session Judge Cuttack to visit the institution where the victim girl was staying, and the London ADJ had an interaction with the victim girl, and in the operative portion of the report furnished by the London ADJ, it is mentioned that the victim is now interested to stay with her parents, and she repeatedly requested her to send her to her native village at Amarpada, Niyali, where her parents and her younger brother are residing. The Land Council for the petitioner also submits that the petitioner is ready and willing to take care of her daughter. In view of such submission, let the petitioner appear before the authorities of International Indecency Prevention Movement, IIPM Cuttack, known as Shobhaniya Sikhyasram, within a period of situated at Bidanasi, Cuttack, within a period of 1 week from today, upon appear karibe on copy of the order be produced before the authorities. We shall release the victim girl with the petitioner.
And petitioner will produce the Aadhaar card
with proper
and making necessary entry in the relevant register. The London State Council shall intimate the order passed today to the concerned institution. The matter be listed in the third week of January 2024. After 4 weeks, the victim stays with her mother, petitioner. The London GMFC, Niali, shall visit the petitioner's place and try to ascertain about the well-being of the minor daughter of the petitioner and submit a report to this court. In the meantime, if any report is received either from the petitioner or from the victim or from any source regarding any problem to the victim girl, the inspector in charge nearly police station shall take proper care in that respect. Free copy of the order be handed over to the London Council for the state. It was produced in sealed cover and opened. Peruse the report, hala? The report is taken on record for me.
Actually, my lord, any source means the opposite party, they have.
No, we can't stop
No.
that. How can we?
Maybe
But
that,
see,
that will be verified, my lord.
no.
Something will happen.
Something is there also.
Something
You
will
just-
happen and you will not intimate. So how the police will come to know about it? It's not that police will go every day. So any source they get that any kind
that will be verified by the London Times.
civil dispute thila kon thila, that's a different matter. We want the safety of the girl who is now going to stay with her, because the allegation is there that you have given marriage to that girl with
Yes,
somebody else.
somebody else.
So if that is not
And she was away for
yes,
3 months.
right.
How could it be?
So
You are not also very
because
clear.
of this, the child is now expressing her desire.
Yes.
That's why we are passing such order. But the conduct is not expected from a mother that minor girl would be will allow to. All right. So
Copy today, pick up today,
copy yes.
Oblige. Item number 14.
My lord, what production of minor daughter of the petitioner?
Just a minute, Mr. That back portion. IAC that would be better. So we are not directing माने straight से जो कोई चलो सेटा को हमें कर दो चे IAC को approach करीबे petitioner. IAC will take her to that institution. सेठी proper identification ये कि नहीं hand over कर दिया in presence of the IAC. Okay. So just add that.
IAC near it.
IAC near, obviously IAC near. All right. This item number
14.
13, 14.
14. Kindly see the order dated 2011-2023, madam.
A million matter may be taken up next week so that investigation after this court development made in yes. Dakwa ଇଏରେ ରଖିବନି ଓପନ ହେଇଗଲା ହେଲା accused is a known person.
I
Shiva Prasad Jain.
Oh, like 25/9/2007 means 16 years how Dimas is the victim. Okay, at that time 15 years also.
नहीं इटा तो काहे कि से फाइल कला डब्ल्यूपीसीआर टा अछि
सेटा दरकार
इन्वेस्टिगेशन कोन
हम कोन लिखि that I was also pointing out to अपन पर लिखा इतला लास्ट ऑर्डर रे that investigating officer shall apprise this court about the development made in the meantime for rescue of the victim girl and he shall produce the case diary on that day. आपण कोन बोले स्टेप कोन नेले तापरे एफआईआर रजिस्टर्ड हला आपनकर as it appears on what is the date of 79 so more than 2 months have passed.
आफ्टर 20th of November कोन आइछि
हां हमर लास्ट डेट थिला 20/11
आफ्टर 20th of November see what is investigation
20th से सेदिन भी सी बोधे नथिले
किछि न
ना ता पूर्व रहउतला एक तो फर्स्ट डेट
And valid
6/11 फास्ट डेट तेरा 6
हां फास्ट ला 6/11 तो कोन अपन डेवलपमेंट कोन करछेंदी कोहंतु हमु अपन तो किछि लेखिले ना रिपोर्ट रे
पुओ झियो फोन नहीं ना ता मा फोन को पुओर घर फोन को ट्रैकिंग कले से कुआडे कथा हो नहीं बाहर लोक
पुओर बयस केते
पुओर सारे 20
कोन करूची से
काम करे उडे दुकान
मोबाइल दुकान ने अच्छा झियो पढुथिला ना पाठ छाड़ देइथिला
झियो पाठ छाड़ देइथिला
पाठ छाड़ देइथिला तो
झियोर भिणेई घर होची पुओ घर पाखरे ता बडापा तांकर आगुरु लव थिला तांकर बाप झियर बाप पुओर बाप कथा हेले बाहागर करिया पे मीटिंग बसला लास्ट को झियर बाप मना कर देला जो दिन ता पर दिन पुओ झियो पळेले बाहर पळेले
जे से तो गला कि केमती गला को आपण कोन कले वर्तमान से होची माइनर गर्ल आपण ताकू उद्धार करिया पई रेस्क्यू करिया पई कोन कोन स्टेप नै चंदी कोन इन्वेस्टिगेशन कर
बंधु बांधव घर मामू घर सर्च करची
कोडी ता मामू घर
होची सेउटू 10 किलोमीटर पद्म पोखरी सेठी किछि क्लू मिलुनी कि
माने आसीथिला ना नै सेठी
ना आसीनी सीधा पळैची कोडे बंधु बांधव जाईनी तापरे आउ हमर वुमेन चाइल्ड वेलफेयर को चिठी देइछि आ किछि से ता घर फोन सीडीआर पकै दिले किछि मिलुनी क्लू
जियो पुओ किछि नै यार किछि
दुकान लो अकाउंट नाही दिन मजूरी हम 300 टका पाए दुकान अकाउंट नाही से दी जन पळैचंदी किछि तार बंधु बांधव आसुनांती कि खबर फोन भी करू ना
जियोर की सांगो
ना सांगो साथी तार
कांटेक्ट किछि करनी से आपण किछि खबर पई जंदी स्टेटमेंट किछि रिकॉर्ड करलेनी
हां सर करछि
कार से जो मामू घर को जाइथिले सेटा अछि
झियो घर
हां झियोर मामू घर को जाइथिले
हां
लेखि जन केस डायरी जाइथिले बेले
हां जाइथिले बोली केस डायरी करछि
अच्छा तो वर्तमान तो समाने जदी ट्रेस आउट करिवे नाही माने फोन रे तो आपण ऑब्वियसली ताकर नेई नांती तो से फोन आउ यूज करिवे नहीं ताले हाउ यू आर प्लानिंग टू ट्रेस आउट द विक्टिम से कांटेक्ट किछि रखिबे नाही वो तार फैमिली मेंबर को सहित रखिबो नाही जियो ता फैमिली मेंबर को सहित रखिबो किंतु जियो वर्तमान होची माइनर जियो एफआईआर दिया हैची किए नेइची मध्य का संगे जाइची से कथा मध्य लेखा हैची केस मध्य रजिस्टर्ड हे गलानी किडनैपिंग केस सो हाउ यू आर प्लानिंग टू रेस्क्यू दैट विक्टिम गर्ल व्हाट इज द वे आउट
तांकर सारे झियो पुहर तरफरु थारे झियो घर को जाइथिले जे आमे एमिति कंप्रोमाइज कर देबा बोली कहि देले तो पो झियो का संस्पर्श रे आस्तुबे कथा होतबे पळे आसंते झियर बाप स्टेट मना कर दला तला ना मु बसिबिनी कि किछि करिबिनी
के बस मना कर दला
झियर बाप
अच्छा
मु तथापि जाई कहली झियो बाप को मु तु सेना राजी हिथांतु राजी हितले पो झियो पळे आस्तले तापर नाम धरतन तापर जा करतन राजी होनु काहेंगी तो मु कोर्ट करिबि कोर्ट रे जाहा ଏ କହିକି ସେ ରାଜି ହଉ।
ଶୁଣ ଆପଣ ମୋ ଉତ୍ତରଟା ଦେଲେନି। ଆମ ଉତ୍ତର ଯେ ଆମ ପ୍ରଶ୍ନଟା ଥିଲା ଯଦି ଏଇପରି ଭାବେ ସେମାନେ ଯୋଗାଯୋଗ ନ ରଖନ୍ତି ଦେନ୍ କଣ ଆପଣ କେମିତି ପ୍ଲାନିଂ କରନ୍ତି ନା କିଛି ଆଉ କିଛି
ନା ସେ ସୋର୍ସ ନେବି ତାର ସାଙ୍ଗସାଥି ପୁଅର ସାଙ୍ଗସାଥି କିଏ ଅଛି ତାର ସୋର୍ସ ନେଲେ ସେ କୋଉ ହାଇଦ୍ରାବାଦ କି କୁଆଡେ ଯାଇଥିବ ମାସେ କି 2 ମାସ ଭିତରେ ମୁଁ ଖବର ନେଇକି ଇଏ କରିବି ସାର୍ ଲଣ୍ଡର ବହୁତ ପଡିଗଲା
ଯୋଉଠି କାମ କରୁଥିଲା ସେଠିକା ସାଙ୍ଗରେ ବି କାହାର କଣ୍ଟାକ୍ଟ ରଖୁନି
ନା କଣ୍ଟାକ୍ଟ ରଖୁନି
ହୁଁ ଗଲା ବେଳକୁ କିଛି ପଇସା ପତ୍ର ସୁନା ଗହଣା
ନା ସୁନା ଗହଣା କିଛି ନେଇନି ଯାହା ମୋବାଇଲ ଦୋକାନରୁ ଆଡଭାନ୍ସ 2,000 ଟଙ୍କା ନେଇଥିଲା ଆଉ କିଛି ନେଇନି।
ଝିଅ ଘରୁ
ନା ଝିଅ ଘରୁ କିଛି ଯାଇନି। ଝିଅର ଭାଉଜ ସାର୍ ସବୁ ଜାଣିଛି ସେ କିଛି କହୁନି।
ଜାଣିଛି ମାନେ କଣ ଆପଣ ସନ୍ଦେହ କରୁଛନ୍ତି?
ତାଙ୍କର ଆଗରୁ ଯୋଉ ବସିଥିଲା ଝିଅର ଭାଉଜ ଯିଏ ମାନେ ତା ପୁଅର ବନ୍ଧୁବାନ୍ଧବ
ହଁ ମାନେ ଭୁଆ ପଟ ସିଏ ତାର ଫୋନ ଟ୍ରାକିଂ କରୁନାହାନ୍ତି।
ଫୋନ କିଛି ବାହାରୁ ଫୋନ ଆସୁନି।
ବାହାରୁ କଣ ଅନ୍ୟ ଫୋନରୁ କାଳେ କରୁଥିବେ କି ସେଠୁ
ଆସୁନି ସେମିତି କିଛି।
ଆପଣ ଯେହେତୁ କହିଲେ ନା ସନ୍ଦେହ କରୁଛି ଯେ ଭାଉଜ ସବୁ ଜାଣିଛି ବୋଲି
ସେଇ ତା ବାପା ଘର ଲୋକ କହୁଛନ୍ତି ଝିଅର ବାପ ଯିଏ ମାନେ ଇଏ ହବ ତାର ବୋହୁ ମାନେ ତାର ଝିଅର ଭାଉଜ।
So they are closely related to each other. All right, not so and so is present. Tangote report diyon. You are the IIC of Dhamnagar police station. Okay. So and so is present and he has produced the status report. And he has also produced the case diary and submit that various steps have been taken for rescue of the victim girl and he wants some more time in that respect. This matter in the second week of January 2024. The IIC Dhamnagar police station shall remain present with up-to-date instruction.
Is it IIC or OIC?
IO.
IO. Yes.
ମୁଁ ପଚାରିଲି ପରା IIC କି କଣ ଆପଣ IIC ତ
ନା ସାର୍
ଆରେ
IO
ଅଟା ମାର ଦେଇଛନ୍ତି ନା ପଚାରିଲି ମୁଁ ଆପଣ ଆଚ୍ଛା SIO ପୋଲିସ ଧାମନଗର ପୋଲିସ ଷ୍ଟେସନ ତା ନାଁଟା ଲେଖିଦେବେ ଏଇଟା କ୍ଲିକ୍ ମାରିକି ମୁଁ ଦେଇଦିଅନ୍ତୁ ହେଲା। ତ ଏଇଟା ସେକେଣ୍ଡ ୱିକ୍ ରେ ରହିଲା ଜାନୁଆରୀ ମାସରେ ଆ ଭିତରେ କଣ ଆପଣ ଡେଭଲପମେଣ୍ଟ କରିଛନ୍ତି ଏ ଇନଭେଷ୍ଟିଗେସନ ରେ କେତେ ଦୂର କଣ ସ୍टेପ ନେଇଛନ୍ତି ତାର ଡିଟେଲ ଲେଖିକି ଦେବା ଆଜିକା ଡେଟ୍ ପରେ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଯାହା କଲେ ଆମେ ଶୁଣିଲୁ ତ କାଲିଠୁ ଆପଣ କଣ କରୁଛନ୍ତି ସେ ପର୍ଯ୍ୟନ୍ତ ସେ ସବୁ ବିଷୟରେ ଲେଖିକିନି ଆଣିବେ ଷ୍ଟାଟସ୍ ରିପୋର୍ଟ ହେଲା ଠିକ ଅଛି। ଯାହା ବି ହଉ ତାଙ୍କୁ କହିଥିଲୁ ନା ରେଡି କରି ରଖିବା ପାଇଁ ଜଣକୁ କିଏ କୋଉ ମ୍ୟାଟର ପାର୍ଟ ଥିଲା ହଁ ସିଏ ତ ଆହୁରି ବି ଗୋଟେ କହିଥିଲେ 20 PVC ଆର୍ଗୁମେଣ୍ଟ କରିବେ ବୋଲି କହିଥିଲେ। We put a very pertinent question to you on that day. That if the case of the prosecution that she had gone to attend call of nature and she did not return on that evening, whether it was not expected for the family members to have a frantic search and they will just remain silent, that would be a factor to show that rather the deceased had left the house with the appellant husband.
In 161, they have searched that in the midnight and night they are searched when he did not return. That was in the 161 statement.
No, in the court statement,
In
the court, it has been stated that she went with the husband. That means the appellant.
Yes, that was the difference in court.
No, it was that the initial story is also that.
Yes.
Only in that 161, that is also pointed out by my esteemed brother.
That was the difference.
That initial story is that court case is also that. Only that in the 161 statement, something else has been mentioned, that no, the appellant alone left the house
Then
because they perhaps want to arrange a marriage for this one. And then after some time, the deceased went to attend the call of nature. Okay. So that story is there in the 161 statement. And another thing is that you are found in that jungle itself, which was the IU arrested you from that jungle, nearby area. So if we believe now, if we accept the evidence, which is your initial story of the prosecution and the court evidence of this witness, that the appellant and the deceased left together from her parents' house. Okay.
Yes.
And neither the victim returned back to her house nor reached her in-law's place. Her dead body was found inside the jungle, and it's a homicidal death. And there was bangles also there. Of course, that is not established whose bangles is there. But and you also did not reach your house, right?
Yes.
So when this question was put to you, it's a very important circumstance, last seen, and the dead body was detected on the very next day. It's not that the gap was short. You almost in the evening hour, you are living together, and on the next day morning, the dead body was detected. So it is in view of that 106 of the Evidence Act, if you accept that you have the special knowledge, if somebody else has committed murder of your wife, you are to explain it under what circumstances your wife died. So if you have failed in that respect, that is one aspect, and motive part has been stated by, I think, PW4 has been stated.
PW5.
PW4 or 5?
4 does not speak anything. 5 that he has seen that there was the parents are not satisfied because of the poor.
That's
But there is no evidence that the appellant and victim has any difference or
no, that is right. What you say that when they from the date of their marriage, as it appears that they were coming sometimes to the house of the together to the house of the deceased.
Yes,
2-3 times.
2 to 3 times they have come, and they are also not giving any statement that the deceased had ever complained before them that any kind of torture in any connection that was made. So that part is there, but again, this is one important aspect that if we believe that part, then previous statement, of course, is something different in before the 161. And you said on that day that MO1 was having no blood. That was there.
And Nemo was found from his house as per the prosecution story. And he was in jungle. Why he will left the MO1 in house?
No. The IO seized the MO1 from what place?
From his house.
Just a minute.
Under 27 Evidence Act.
Just who is that IO?
PW8.
8. Para
8.
Para 8 onwards.
9.
No, in para 8, he's saying that on the same day I arrested accused at 11:30 a.m. I brought the accused to police station on the same day. The accused while in my custody in presence of witnesses.
Paragraph 10 leading to so and so. Achha, that is a knife.
Yes, sir.
Okay, I recorded the statement. Therefore, the accused in presence of so and so brought out the knife from
the low-level bhadi
and handed over to me. And this is the seizure list. I seized the knife. This was sent for that C examination, and no blood was detected.
So this may not be the weapon.
Yes, blood stain. Knife ta कितने mark है
D.
D. Okay, D रे किसी blood नहीं. And what about the doctor who conducted post-mortem examination? Who is he? PW 9?
No, PW 6.
That knife was supplied before him, Your Lordship, for examination.
Produced.
And he has examined and stated that could have been possible from that knife.
No, any kind of sharp cut injury, so that was possible. So obviously he has opined.
In chief, he has said that it is the injury is the antemortem nature, but in report he has not mentioned that the injury.
There was a cut wound on the neck of the. So obviously it's a sharp cutting weapon. That is how he has opined.
The larynx and trachea have been found caught.
If that part is taking into account, then that means that after committing the crime, he has come to his own house. If your case is believed,
yes,
concealed the weapon and
then left.
In that case, what prompted the mother of the appellant to come to the house of the deceased in search of the appellant and the deceased? That means if at all he had gone there just for the sake of hiding the weapon of offense, the inmates of the house of the appellants have not seen him.
Might not have been aware that he came
Yes.
secretly and constantly. And it was se bahare kodi gote genji deikini bahar bhadi.
So this to the IO, he has arrested from jungle.
That is
right.
There is ample space to hide the why if he
No,
will
the
have
entire evening was there, na? Entire night was there.
See,
Entire night was there.
Taro, police ko so and so state pleading to some rescue discovery. Lower level body handed over.
ତାମାନେ ଏମିତି ଯୋଉଟା ହେଇଥିବ ସେ ଜାଗାରେ ହେଇଥିବ ଯେ and the period was entire evening.
ଯାହା ହେଇଛି ସନ୍ଧ୍ୟା ଭିତରେ ହେଇଛି. Because on the next day the dead body was recovered
and she has already come by 5 o'clock in the morning. So it could not have been in the morning. Whatever has happened, it is only after late evening or in the dead night.
The mother of the accused also came in search of the accused.
Yes, that was the FIR story. That.
Now the only thing which is somehow relevant according to you is that the previous statement given by these witnesses. Otherwise,
other things are there.
And then motive is also doubtful. Motive is doubtful. That were two motives they have said. PW4 one said one motive and PW5 another.
But why you say another?
That they will marriage.
They will give their daughter in marriage with someone else. Yes, that is the only.
They will marriage PW5 are saying that they are their parents are shouting the accused for why he has married a poor girl. But PW4 side we have arranged another man for that.
Yes, it is in their same context only. That because of the fact that the accused is poor and he was not doing anything. So probably there is an altercation and
they want to marry.
They want to keep the marriage of their daughter at another place.
So, and the PW5 that they are not happy, for which they are quarreling with the accused and also the.
So after that, whether he left alone or he left together.
Two motives so that they are torturing for money or anything.
No. Again, we are coming back to that. Suppose if we believe that both of you have lived together from the house of the parents of the so and so, and on the till the next day when the dead body was recovered, neither the accused came to his own house nor the deceased returned back to his own house or reached the house of the in-laws. And in the
wee hour of the day, in the wee hour of the day, the mother is coming to the house of deceased
for search of the child. That means for search of the, and she was informed that he have already left. Then in the morning hour, the dead body was detected, and it's a homicidal death. Caught injury is there.
And it seems also that at the time of search of the dead body, the father of the appellant was also present.
No, father, he has called after found the dead body. Informant called the father of the appellant and guard him the dead body. Then he had gone to the police station to lodge it.
So the parents of the appellant were also not indifferent to this situation. They had rightly come, guarded the body as per the wishes of the father of the deceased.
So even if the different type of statement is there, but why not we rely on the evidence which is also appears to be natural because of the other circumstances? We pointed out that how an improbable story would be if we say that he left and then she went to attend the call of nature, did not return, and thereafter there is In that 161 that is there, but you have not even proved that portion to the. Have you confronted that portion to
No,
the?
it was left halfway.
No, you have
That
left it
part was not
halfway.
been
That we are
touched.
verifying it on that.
That part was not put.
Who is that witness? PW? Four.
He has
Who election je? He did not return that house. ସେତିକି ତ ସହି ଦେ ଯେ ଗଲେ ଖୋଜିଲେ ଇଏ କଲେ ଏଗୁଡା କୋଉଠି ଆସିଲା?
it is not fact that it's para 6 page.
हाँ para 6 ही हमें दो page 44 तो हाँ just read it out once again. It's not a fact. Please read out.
It is not a fact that I have not stated before the IO that the deceased and the accused together left our house on 4/1/2007 at 5 p.m. It is not a fact that I have stated before the IO the first accused left my home in the evening when my daughter refused to go with him, and sometime after departure of the accused, my daughter left home to attend call of nature, but she did not return in that night. It is not a fact that I stated before the IO that on 4/1/2007, when accused asked my daughter to go with him back to his home, my wife and my daughter did not agree despite of repeated persuasion by the accused. Question
ସେଇ କାଇଁ ସେଇ ପୋର୍ସନ ଟା ଯୋଉ ଖୋଜିଲେ ଆମେ ଯାଇକିନି ଯାଇଥିଲେ ଯୋଉ ସେଠିକି ଖୋଜିବା ପାଇଁ ସେ ତ
ଆଇଓ ଖାଲି ପଚାରିଛନ୍ତି ଏଇଟା କହିଛି କି ନା
ଛାଡ଼ିଦେଲେ ନା
that is the vital part.
that should vital part ହେଇଥାନ୍ତା ଆପଣ ବର୍ତ୍ତମାନ ଯୋଉଟା କହୁଛନ୍ତି ନା ସେଇ ଯୋଉଟା କହିଲେ କଣ୍ଡକ୍ଟ ଟା ସେ ଗଲେ ଖୋଜିଲେ ପାଇଲେନି ଆମେ ଯୋଉଟା ପଚାରୁଛୁ ମଧ୍ୟ ତାର କଣ କଣ୍ଡକ୍ଟ ହେଇଥାନ୍ତା ତ ସେ ଏଭିଡେନ୍ସ କାଇଁ 161 ରେ ଯୋଉଟା ରହିଗଲା ସେଟା ଉଝିଅ ହେଇ ରହିଗଲା. So opportunity has not been given to the. So if it is a material omission, so it should have been brought and in the manner has been laid down in the Evidence Act that is to be proved. 162 coupled with that there is a procedure how it is to be proved. So we cannot just look into the 161 statement and use it as freely, and it is to be done in a proper manner. So
that was asked to the IO, but IO then he has said that I did not ask any further question. That was asked to the IO. He had said that 161. He has said that the accused had gone first, then the victim had gone to call of.
ନା ଆମେ ଦେଖିଲୁ ପରା ଆମେ ତ ସେଇଆ ଲେଖା ହେଇଛି
ନାଇଁ ସେଇଟା ତାପରେ ପଚାରୁନାହାନ୍ତି ସେଇଟା SBC court.
ଚାରି 1/2000 ସନ୍ଧ୍ୟାରେ ମୋର ଝିଅ ସୁଆଣ୍ଡସୋକୁ ତା ଘରକୁ ନେଇ ଯାଉଥିବା ଏଇଟା ତ ଗଲା ତା ପୂର୍ବରୁ ଅଛି ସନ୍ଧ୍ୟାରେ ସେ 2 ଜଣ ଯାକ କଣ କୁସୁମ ବାଟା ଯିବା ବୋଲି କହି ଚାଲିଗଲେ ଆଜି 5ରେ ସୁଆଣ୍ଡସୋ ପହଞ୍ଚି ଏଇ ଟାଇପ ର ଷ୍ଟେଟମେଣ୍ଟ ବେସ୍ କରିକିନି ଜଣେ ଯଦି FIR ଦବ ତା ପର ମୁହୂର୍ତ୍ତରେ he would be examined on the same day. Say informant କେତେବେଳେ examine ହେଲା ଏଇ IO ର ଦେଖୁନାହାନ୍ତି evidence they receive the FIR wants to examine
4ଟା ବେଳେ ଦେଇଛନ୍ତି ତାପରେ
ତ ସାଙ୍ଗେ ସାଙ୍ଗେ ସେ ମତ ପରିବର୍ତ୍ତନ କରିଦବ FIR ଟା ଦଉଛି ଗୋଟେ ଲାଇଟ ରେ ତାପରେ କହିଦବ ନାଇଁ ସିଏ ଅଲଗା ଗଲା ଇଏ ଅଲଗା ଗଲା ସିଏ ଗଲା it's a completely different story
and again switching in the evidence to the previous one.
ଆଇଓ ତ ଧରିଥାନ୍ତା ନା ତୁ ଏତେଲାରେ କଣ ଲେଖିଛୁ ସାଙ୍ଗ ହେଇକି ଗଲେ ବର୍ତ୍ତମାନ କଣ କହୁଛୁ କଣ ଇଏ ଗଲାଣି ଆଗରୁ ସେ so something is appears that apart from the other surrounding circumstances this statement which has been recorded is but of course there are some decisions that in such a situation the the public prosecutor should have declared that, made a statement that, that investigating officer, that you have not correctly recorded the statement of that witness. So, see, kahidi chali gala na mane.
So in any way,
But
the investigation will not rule the roost.
that's right. So, or we'll continue.
Lordship.
For the time.
Pardon to mention, your lordship.
With the lordship's kind permission,
My lord, may I mention?
one matter has been specifically adjourned to a specific date, my lord, but subsequently then didn't come in the list.
Give the memo.
Petitioner is a old man, my lord, 82 years old. Service benefit is
Yes.
Pardon to mention.
Yeah.
Pardon to mention, your lordship. Criminal division number 626, 636, 638. 2023 में the petitioners are juveniles.
Yeah.
Yes, sir.
Criminal appeal for bail.
Item 186, my lord. Your lordship permitted to withdraw the withdraw memo already filed.
186 withdrawal memo file is
Again.
Page 2.
Yes.
Page 26.
मला item 2.0 my lord. ମାନେ defect ଅଛି 5D copy already solved my lord.
କଣ କେତେ
210 210 my lord. Fresh matter ଟା my lord.
Fresh matter for କଣ
For
criminal appeal conviction.
my lord.
What is the sentence import?
Sentence is 20 years my lord. 376 3 my lord.
But there is a delay of
No my lord.
no delay.
No delay. In time.
Limitation, okay.
I have to I am my lord not reflected in the noting my lord.
$20 years is
My
this.
lord, 20 years.
And 376 3 is there, so notice has to be.
My lord.
So you have served the copy.
My lord, copy already served.
This is item number 210. Mr. Das, he said that copy has been served in item number 10, 210. So verified
Item
210. Learning counsel for the appellant submit that he has already served the copy of the appeal memo along with the impugned judgment and interim applications on the learning counsel for the state. Therefore, the defect number 5D as per SR has already been removed. Admit call for the trial court record. Next IA number so and so. This is an application for bail. Since one of the offense under which the petitioner has been found guilty is under section 376 bracket 3 of the Indian Penal Code. Let an extra copy of the appeal memo along with the impugned judgment and copies of the interim application be served on the learned counsel for the state. This shall be sent to the inspector in charge of Odogaon Police Station for its service and the informant of Odogaon PS case number 101 of 2019 by usual order for them. Yes.
Item 198.
Common
Item 198.
any date, madam?
Nah.
Item 198.
198.
Yes, page 20. So it's 10 years conviction, 6 years above already in custody, my lord.
I will take up matters.
Not taken up.
Yes. Yes, sir.
My lord, item 214, my lords.
Yeah.
It's a condonation of delay, my lord.
What is this criminal appeal for, Mr. Roy?
My lord, against the order of the London Special Court.
Yes, conviction matter.
Yes.
What is the punishment imposed?
My lord, 7 years.
So, what defects are there? Apart
My
from
lord,
the
condonation of delay, my lord.
no, that's all right. এটা বাহার করো কেতে দিন দিলে তো স্ট্যাম্প রিপোর্টিংটা
18 days.
এই স্ট্যাম্প রিপোর্টিং দিও Just a minute.
My lord.
Why it has not been done? That piece. IA number 2826 of 2023. There is an application for condonation of delay in filing the criminal appeal. The stamp reporter has pointed out that there is delay of 19 days in filing the criminal appeal. After going through the averments taken in the interim application and hearing the learned counsel for both the parties, since the criminal appeal arises out of conviction matter in which the London trial court has imposed sentence of what is the year?
Pardon?
What is the sentence imposed? 10 years.
10 years, but he is a juvenile at the time of
10 years. I am inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit, call for the trial court record. Since one of the offense under which the appellant has been found guilty under section 376 AB of the Indian Penal Code. Extra
my lord, 370 is acquitted, my lord. Under section 16 and 18, my lord, he was convicted. Under section 16 and 18 of POCSO Act, my lords.
This is item number
214.
Yes, you have also been found guilty under section 376 AB. You come to the paragraph number 16. No separate sentence has been imposed, but you have been found guilty under section 376 AB because the punishment has It ends only in 219. Which date list you are holding? Today, the list is only up to 219. So maybe that's some other day's list you are. Yes.
Item 22, my lord.
You have not heard what I have told. You wait till the matter reaches. Yes.
213, my lord.
Yes.
Against conviction under section 306, an RI for 10 years,
Yeah.
the delay of 32 days in filing appeal. 213.
Wait.
Lord, 20 I see 10 years, my lord. Out of 10 years, my lord, more than 8 years in custody, my lord. You are granted.
When the matter reaches, we'll see that.
My lord,
My lord,
Lordship, I just seek your kind permission to mention one very urgent matter. Lordship, the father of the petitioner died on 17th. And from 17th, we are trying our level best to mention the matter. And he is the only son of his father. At least he should be allowed to participate for a single day cremation is fixed on 13th.
No,
Since
outsiders, unless I verify the address, etc., that cannot be.
Yes, Lordship, Lordship can do. At least matter should be taken, Lordship.
Yes,
Tomorrow in the supplementary list, please, Lordship.
If he knew that.
Yes, Lordship. We have filed.
The matter is in the item number? Today's list.
No, Lordship. It's on the Thursday, Friday list. And Thursday is the last day. On that day, Terami will take place.
Where is your application for that?
Sir, Lordship, I filed 5 days ago.
Huh?
I have filed IA 5 days ago. Last week only I filed. On the 17th only. Lordship, the IA number.
What is the IA number?
Lordship, IA number is 1526.
1526 of?
Yes. This year, 23.
2023.
Yes, Lordship. And the
You
bail
have served
application
a
number is,
copy on the State Council.
yes, Lordship. Yes, it has been served by
এটা
associate.
ଟିକେ ଦେଖିବେ ତାର କଣ ହେଇଛି এটা take down 219
1526
mention
oblique
is
23.
paid on behalf of Mr. By
Shyam Manohar.
Mr. Shyam Manohar, Land Council, appearing through virtual mode, that though this case has been listed in the weekly list dated 30th November and 1st December 2023 as item number 219, but the father of the petitioner has expired and he has filed an interim application by IN number 1526 of 2023 for interim bail, and the matter may be listed tomorrow along with IN number 1526 of 2023. Land Council for the state shall obtain instruction on the interim application. Please
My
this
Lord,
matter
I'm
tomorrow with IN.
obliged. I'm deeply obliged, Lordship.
Yes.
Again, see that.
Weekly list item number 1.
Please, Your Lordship. Just my conviction under section 354A, 2 years, my lord.
Senior,
Page,
running
page.
page 73, man.
73.
Man.
I sentence convict so and so to RI for 10 years. Okay. 20B2C. Admit call for the trial court record. Interim applications for bail and sterilization of fine to be considered after receipt of the trial. Yes.
Oblige.
Item 6.
Yeah, please, your lordship. At running page number 39, appellant has been
May I please, your lordship. Appellant my lord convicted on 20B2C of NDPS Act.
Page.
Well, 57, 58, the last 58, my lord. The operative.
58. Convict Manoj Kumar.
Manoj Kumar Patra.
Sentence to so and so RI for 10 years. Okay. Admit call for the trial court record. Interim applications for bail and sterilization of fine to be considered after receipt of the trial. Yes.
And deposition copy already annexed.
All right. That's
Item 8.
My lord, the appellant is convict offense under section my lord 13(2) and 13(1)(d) of the PC Act, my lord. That is the conviction period is 4 years.
Page.
The operating page is my lord 88. Para 30, my lord.
Page टा कितने को ना दी?
88, my lord. Running page 88.
अच्छा. तो किसी नहीं और रनिंग पेज 88 पूरा.
Running page 88, my
हाँ
lord.
ठीक है. All right. I sentence the convict to undergo RI for 4 years and to pay fine of ₹2,000. In default to undergo RI for 2 months under 13(2), read with section so and so. It's a trap case.
Yes, my lord, trap case.
Then RI for 3 years, 2,000 in default RI for 2 months.
2 months only.
7 of the so and so. So it is to run concurrently. That means you are 4 years is there.
My lord.
So you must have been taken into custody
Yes,
after.
my lord. And the date of
You,
judgment.
you are on bail during trial.
Yes, my lord.
Yes, Mr. Das.
Yes, my lord. I have already filed my appearance memo on 24/11.
24/11, 2023. Heard Mr. Sanjay Kumar Das, London Standing Counsel for the Vigilance Department, who submits that he has already filed his appearance memo on 24/11/2023. The registry shall place the same on record. Henceforth, the name of Mr. Das be reflected in the cause list, also in the top of the brief. Hard admit call for the trial court record. IA for bail. He was on bail, but after conviction, he has been taken into judicial custody. No chance of early hearing. Bail allowed. Sterilization of fine.
3 copy of the order.
3 copy of the order. Yes.
Obliged.
Item 9.
थोड़ा दे दियंतु अपन.
13टा notice यो. AB ଅଛି.
AB ଅଛି କି? अच्छा. So 9, 10, 11, 12 जोड़ाको 3टा आधीरो टाइम रे अछि आ गुड़ाको लेट रे अछि. तो डिले कौन कर देबे. advocates engaged. So far as JCRL is 16 days since one of the offense is under section 376 AB. Either last item 13 and notice ଯିବ ହେଲା ସେଇଟାରେ obviously ଆସିଲା ପରେ ତାକୁ ଇଏ କରାଯିବ ହଁ ଏଇଟା ଦେଇ ଦେଇଛନ୍ତି କି ନା ଦେଇ ଦେଇଛନ୍ତି ହଁ then it's all right ଠିକ ଅଛି ନା ଦେଇଛନ୍ତି ଦେଖିବ ये जोटा माने आइटम नंबर 13 ने एडवोकेट एंगेज कर देवे फॉर कंसिडरेशन ऑफ द एप्लीकेशन फॉर डिले नोटिस इज टू बी इशूड सिंस वन ऑफ द ऑफेंस इज 376 AB हैला ठीक है ऑलराइट
Item 14.
एटा कौन नोटिस सर्व हैला
नोटिस सर्व ହେଇଛି ଲାଷ୍ଟ ଅକେଜନ କେହି ନଥିଲେ
Item 15. Item 16.
14, my lord. Pardon.
Yes, 16.
My lord, item 14.
14 is already over, non-appear. Item number 14, Gupta Hantal, CRLA number 55 of 2021. It's a 21 matter. I have asked that if non-appears for the appellant. It's a criminal appeal in the bail application in the form of criminal appeal.
So
Item number 16. The appellant is at liberty to renew the prayer for bail if the case is still sub judice before the trial court. Criminal appeal stands dismissed for non-prosecution. Yes.
Item 17.
May I take the my lord, on 20th and 21st. 20th, 21st and 22nd. For these 3 days, I was submitting before your lordship pleadings of respective parties in paragraph 7A and 23A with respect to form 20B, 2B. 12 issues which were settled by my lord
relating to that form 2B.
relating to that form 2B. And documents marked on exhibit on behalf of election petitions.
Right.
But today I beg to invite your lordship's kind attention. So far as the oral evidence is concerned, the election petitioner has examined himself as PW1 and the returning officer whose order has been challenged has been examined as PW3. I would like to place the substantial portions of PW3, both asked in chief as well as in cross-examination. So far as your lordship may kindly turn to paragraph 2.
PW3.
PW3.
Paragraph?
Paragraph 1 will be achi. Paragraph 1 at page 1 and 2. The relevant portion is, it is a fact that all the candidates who contested the election of 90 Baravati Kotak Assembly constituency held in the year 2019 filed their nomination papers in Form 2B. Annexure 11 of Exhibit 38 Exhibit 38 say sentence paragraphs or last 4-5
I have already marked.
Then your lordship kindly come to paragraph 2.
Because Mr. Mishra, we have understood that both of you will just pinpoint.
I am only pinpointing. I am only pinpointing
If
and
we vote also just issue numbers one, so just paragraph.
Paragraphs.
Yes.
In my note, written note, I will indicate that, but only said
No.
placed now before your lordship. Master,
Obviously. Yes.
There is a part 2 in annexure 11 marked as exhibit 38/3. Paragraph 2 there achi.
Yes.
Okay. Part 2 of annexure 2 is not there in exhibit 39. Exhibit 39 is the nomination. First set of nomination. It is a fact that in nomination paper filed by the respondent before me marked as exhibit 39, clause C2 of part 3 is not there, even though the same is there in annexure 11. Exhibit 38/3 at page 358. It is a fact that the respondent has not filled up the column under 1 to 12 at page 3 of his nomination paper exhibit 39. It is a fact that I have accepted the nomination paper Exhibit 39, wherein column under 1 to 12 at page 3 are blank. Only material portions. সেটা হচ্ছে part 3 এর column 1.
Right.
Then there is a part 2 in annexure 11 marked as 38/3. Part 2 of annexure 11 is not there in exhibit 40. এটা paragraph 3.
Mark for 7.
It is a fact that in the nomination paper filed by the respondent before me, marked as exhibit 40 clause CII part 3 is not there, even though the same is there in annexure 11 exhibit 38/3 at page 358. Is exhibit 40, that is the second set of my nomination. It is a fact that I have accepted the nomination paper exhibit 40 wherein the columns under I to 12 at page 3 are left blank. Part 3 era column 1. Sub column gudak. Then your lordship come to paragraph 4. This is nomination serial number
04.
04. And exhibit 41. After receiving the same from the respondent, I put serial number, date, and also time, and also given my signature thereon. There is a part 2 in annexure 11 marked as exhibit 38/3. Part 2 of annexure 11 is not there in exhibit 41. It's a fact that in nomination paper filed by the respondent before me marked as exhibit 41, clause CII of part 3A, এটা 3A na? 3 is not there, even though the same is there in annexure 11 38/3. It's a fact that the respondent has not filled up the columns I to XII at page 3 of his nomination paper 41. এটা হচ্ছে 3A. It's a fact that I have accepted the nomination exhibit 41, wherein the column under I to XII at page 3 are left blank. Then your lordship may come to paragraph 5 at page 5. There is a part 2 in annexure 11 marked as 38/3. Part 2 of annexure 11 is not there in exhibit 42. It is a fact that in the nomination paper filed by the nomination, it is a fact that nomination paper filed by the respondent before me marked as exhibit 41 clause CII of part 3 is not there, even though the same is there in annexure 11 exhibit 38/3. It's a fact that the respondent has filled up the column under I to XII at page 3 of his nomination paper exhibit 42. It's a fact that I have accepted the nomination paper exhibit 42. Then paragraph 6 at page 5.
These provisions were put.
Provisions.
Not necessarily.
Then your lordship may come to paragraph 7. Every candidate paragraph 7. According to Section 33 of the Representation of People Act 1951, the candidates contesting the General Assembly election of 90 Baravati Kotak Assembly constituency held in the year 2019 are supposed to deliver to me as returning officer their nomination paper in the prescribed forms, signed by the respective candidate and by an elector of the constituency as proposed. It's a fact that Rule 4 of Conduct of Election Rules 1961, every nomination paper presented under subsection 1 of section 33 shall be completed in one of the forms 2A to 2E as may be appropriate, and so far as 90 Baravati Kotak Assembly constituency is concerned, each candidate contesting the general election in the year 2019 was required to submit his nomination paper before me in the prescribed Form 2B. Form 2B is appended to the Conduct of Election Rules 1961. It's a fact that Form 2B, which is available in the handbook marked as Exhibit 38/3, is the same as Form 2B appended to the Conduct of Election Rules 1961. Every candidate who was supposed to contest the General Assembly election of 90 Baravati Kotak Assembly constituency held in the year 2019 was required to file his nomination paper in Form 2B only as appended to the Conduct of Election Rules 1961. It's a fact that every candidate who wanted to contest the General Assembly election of 90 Baravati Kotak Assembly constituency held in the year 2019 can be permitted to file his nomination paper in Form 2B only as appended to the Conduct of Election Rules 1961 and not in any other forms. Question: whether the nomination papers filed by the respondent in Exhibit 39, 40, 41, 42 are exactly in the prescribed Form 2B as appended to the Conduct of Election Rules 1961 in all respect. Answer: nomination papers filed by the respondent in Exhibit 39, 40, 41, 42 are not exactly in the prescribed Form 2B as appended to the Conduct of Election Rules 1961 in all respect. Please verify the nomination papers in Exhibit 39, 40, 41 and 42 filed by the respondent and answer whether Part 2 of Form 2B as appended to the Conduct of Election Rules 1961 is available therein. No, it is not there. Please verify the nomination papers in Exhibit 39, 40, 41 and 42 filed by the respondent and answer whether Clause CI of Part 3 of Form CIII Form 2B as appended to the Conduct of Election Rules 1961 is available therein. No, it is not there. Whether you have accepted the nomination paper in Exhibit 39, 40, 41, 42 filed by the respondent, even though it is not exactly the same as per the prescribed Form 2B as appended to Conduct of Election Rules 1961? Yes. Can you show any provision in the Representation of the People's Act 1951, Conduct of Election Rules 1961 or instructions issued by the Election Commission of India in the handbook marked as Exhibit 38 that the returning officer has been given discretion to accept a nomination paper from a candidate even though it is not exactly the same as per the prescribed Form 2B as appended to Conduct of Election Rules 1961? Answer: as per the provisions of subsection 4 of section 33 of the Representation of People Act 1951, including the proviso to such subsection, As a returning officer, I had the discretion to accept the nomination papers of the respondent in Exhibit 39, 40, 41, 42, even though it is not exactly the same as Form 2B appended to the Conduct of Election Rules 1961. Question. It is put to you that in view of the proviso to subsection 4 of section 33 of the Representation of People Act 1951, the returning officer has only been given a discretion to overlook any misnomer, inaccurate description, clerical, technical, or printing error in the electoral roll or in the nomination paper, and no other things. It's a fact. It is put to you that no discretion has been given to you to accept the nomination papers of the respondent in Exhibit 39, 40, 41, and 42 in the manner in which those were presented before you as a returning officer by deleting Part 2 and Clause CII of Part 3 of Form 2B as appended to the Conduct of Election Rules 1961. Yes, I have been given the discretion to accept the nomination papers of the respondent in Exhibit 39, 40, 41, and 42 in the manner in which those were presented before me in view of the proviso to subsection 4 of section 33 of the Representation of People Act 1951. Is there any other provision anywhere prescribed giving discretion to you as a returning officer for accepting a nomination paper which is not exactly the same as per Form 2B as appended to the Conduct of Election Rules 1961, except proviso to subsection 4 of section 33 of Representation of People Act 1951. There is no other provision except proviso to subsection 4 of section 33 of the Representation of People Act 1951. Question. It's put to you that no discretion has been given to you as a returning officer under the proviso to subsection 4 of section 33 of the Representation of the People Act 1951 for accepting a nomination paper which is not exactly the same as per Form 2B as appended to the Conduct of Election Rules 1961. It's not a fact. Then your Lordship kindly turn to paragraph 20, page 24. Your Lordship got it?
Just
Mind. On 2/4/2019,
20 na 24?
paragraph 20 at page 24.
Yes.
On 2/4/2019, I personally verified the 4 sets of nomination papers under Exhibit 39, Exhibit 40, Exhibit 41, and Exhibit 42, along with the accompanying documents and affidavits under Exhibit 39(1), Exhibit 41, Exhibit 41 by 1, and Exhibit 42 by 1, one after another. I cannot say how much time it took to verify each set of nomination paper along with the accompanying documents and affidavit, even approximately. After verifying first set of nomination paper along with the accompanying documents and affidavit, I prepared one checklist and then I proceeded to verify the second set and in the like manner third set and fourth set. Then paragraph 26 at page 25 and 26. Bottom arrow.
It's not a fact that in violation.
It's not a fact. It's not a fact that in violation of the provisions contemplated under the provisions of under the Representation of People's Act 1951, the Conduct of Election Rules 1961, and Handbook of Returning Officer Exhibit 38, I accepted Exhibit 39, 40, and Exhibit 41 and 42, and Exhibit 43, Exhibit 44, Exhibit 45, Exhibit 46. It is not a fact that I have not received the affidavits of the respondent under Exhibit 39 by 1, Exhibit 40 by 1, Exhibit 41 by 1, Exhibit 42 by 1 on 2/4/2019. This is with respect to the affidavit dated 2/4.
Yes.
Here, your lordship will mark that consistently and effectively the returning officer is denying the suggestions given by the learned counsel appearing for the election petitioner.
No, he's accepting that some columns have been not filled up, some have been
Yes, he
omitted.
said. Primarily, he said these are
Right.
because those are facts. So, despite that fact, I have accepted it.
Yes.
Because I have
the discretion.
Discretion under 33, proviso to section 33(4). And thereafter, also there are material denial to the suggestion of the counsel for the election petitioner. I am going to place that. Then your lordship may kindly
No, another thing, Mr. Mishra, this से जो लाइन टा कहलेनी जोटा एटा मोर जो डिस्क्रिप्शन अछि आउ क्लरिकल एटा सेटा टिके आसिले हाँ को पैराग्राफ रे सेटा देखौथिलो से क्लरिकल हमको एई चारटा पांचटा कारण पई हमें मोर डिस्क्रिप्शन अछि ताकू
I will place the provision also.
No, से लाइन टा से पढ़
Evidence रे खोजते
हाँ एविडेंस आपण अभी पढ़िले सर
एटा
हाँ पेज 8 अच्छा ठीक है पेज 8 को Okay, that is page number 8. 8 जो second question टा बोले Q हाँ second Q टा देखो page 8 को ऐसे ले
हाँ it is put to you.
हाँ that's
it is put to you that in view of the proviso to subsection 4 of section 33 of the Representation of People Act 1951, the returning officer has only been given a discretion to overlook any misnomer, inaccurate description, clerical, technical, or printing error in the electoral roll or in the nomination paper and no other thing.
No, it's all right. Have any questions been put by the counsel for the election petitioner that this type of defects which are appearing which are appearing in the nomination paper, that omission of some parts, some columns, etc., not filling up, it would come within which category? That means whether it is a clerical, whether it's a inaccurate, same thing. And
से language टा पढ़िबे से particular 33(4) provide
एटा तो पूरा एग्जैक्टली से कोट हिच
से भी कहउचंती रिटर्निंग अफसर सतरे अनेक गुडा अछि
नै सेमानकर क्वेश्चन
समाने करनाती
सेमानकर पचारिवार थिला जे
आ भितरु को कैटेगरी रे आसी
हाँ एई जोटा ये आपण जो कहउछंती आकु कंडोन कर देले जे इन स्पाइट ऑफ ओमिशन इन स्पाइट ऑफ नॉन फिलिंग ऑफ दिस कॉलम्स बा जो इगुडा को डिलीट हे जैछि
डिलीटिंग पार्ट 2
एई गुडा को जो एटा को कैटेगरी रे आसीबो तेणु सजेशन नाही जे एगुडा को से कैटेगरी रे आसीबो नुहे तेणु आपण
सजेशन नाही
हाँ हाँ
नेक्स्ट क्वेश्चन रे भी से अछि
हाँ
it is put to you that no discretion has been given to you to accept the nomination papers of respondent in exhibit 39 40 41 and 42 in the manner in which those were presented before you as a returning officer by deleting part 2 and clause CII of part 3 of form 2B as appended to the conduct of election rules से कहले तुमको दिया जाए नहीं आंसर ये कहले yes I have been given discretion to accept the nomination papers of respondent in exhibit 39 40 41 and 42 in the manner in which those were presented before me in view of the proviso to subsection 4 of section 34 of the representation of the people act 19 तापरे आपण जो कहउचंती से आ तांको सजेशन देई नाहंती को हेडिंग रे एटा पडु
हां सेही हम
नाही देई ना
okay
I think your lordship has noted that mind question
just a minute
a page ये paragraph 26 page 25 and 26 पर्यंत is limited to their examination in chief lastly they gave a suggestion at paragraph 26 at page 25 and 26 I invite your lordship's kind attention to their last suggestion at paragraph 26 page 25 and 26 bottom aduku seta achi
so
tankara suggestion thila that you have accepted the nominations of the respondent in violation of provisions contemplated under the Representation of People's Act, Conduct of Election Rules 61, Handbook of Returning Officer 38.
ना ना एटा तो जनरली कहि देले
सेतिकी
हां
आउ किछि आपण जेंति चाहुचंती स्पेसिफिक सजेशन नो सच सजेशन हैज बीन गिवन
केवल स्पेसिफिक सजेशन दबार नथिला ता सहित मध्य सजेशन दबार थिला कि आपण जो कहउचंती ना एटा क्लरिकल बेली बा एटा inaccurate description that is not correct that is you have illegally accepted this is does not come within that category
yes
so that should
rather
have
it comes under category of illegal and improper acceptance সেই দুইটা যাক সজেশন কনস্পিকুয়াসলি absent ତାଙ୍କର ପ୍ଲିଡିଂ ରେ ବି ନାହିଁ if your lordship remembers ଖାଲି ପ୍ରେସ୍କ୍ରାଇବ୍ଡ ଫର୍ମ ରେ ନାହିଁ ବୋଲି
prescribed form ନାହିଁ ତାପରେ ଟିକେ ଡିଟେଲ କରି ଦେଇଛନ୍ତି ଏଥିରେ
I will show to your lordship how touchy the honorable Supreme Court about the absence of
pleading
ମୁଁ ଗୋଟେ କେସ୍ ଏଇଠି କରିଥିଲି Odisha High Court. Sanatan Mahaprabhuଙ୍କ ତରଫ against ଜିତୁ ପଟ୍ଟନାୟକ ସେଥିରେ ଆମର କେତେ ଗୁଡାକ ପାରାଗ୍ରାଫ କୁ ଷ୍ଟ୍ରକ୍ ଆଉଟ୍ କରିଦେଲେ କିନ୍ତୁ କେତେ ଗୁଡାକ ଏଠି ରଖିଲେ ଜଷ୍ଟିସ ବିଶ୍ୱାଳ as the election judge. ତା against ରେ ଜିତୁ ପଟ୍ଟନାୟକ carried appeal to the Supreme Court. ସେ ଯୋଉ ପାରାଗ୍ରାଫ ଗୁଡା ରହିଲା ସେଥିରେ ମୁଁ describe କରିଥିଲି on behalf of the election petitioner ଯେ the voters came to the booth, signed the register, and went in the process to the voting chamber. କିନ୍ତୁ ମୁଁ ଲେଖିନଥିଲି and they voted. They went to the counting chamber ପର୍ଯ୍ୟନ୍ତ ଗଲେ, which obviously means that they have come to the booth and voted. କିନ୍ତୁ ମୋର there was only one word missing in my pleading and the voters voted. ସେ voted ଶବ୍ଦଟା ନଥିଲା ବୋଲିକି my election petition was rejected. I will be citing that decision before your mercy. Jitu Patnaik versus Sanatan Mahakur, I think in 2012 Supreme Court. It is not a fact, the last suggestion I am placing before your mercy. It is not a fact that in violation of the provisions contemplated under Representation of People Act 1951, Conduct of Election Rules 1961, and Handbook of Returning Officer Exhibit 38, I accepted Exhibit 39, 40, 41, 42, and 43, 44, 45, and 46. It is not a fact that I have not received the affidavit of the respondent under Exhibit 39 by 1, 40 by 1, 41 by 1, and 42 by 1 on 2/4/2019. এটা 2 ତାରିଖର affidavit.
नहीं कारण तार गोटे प्रोविजन रहुची 33(4) रे तार गोटे डिस्क्रिप्शन रहुची एई जिंस गुडाक को सी इग्नोर करि परिबो तेणु जदि तमर केस होउची जे एई जो डिफेक्ट गुडाक जहा अपियर करूची आर जो चारटा सेट ऑफ नॉमिनेशन पेपर रे
तुमरा 33(4) पावते इग्नोर
करि परिबो नाही ताहले it was your duty to specifically put that question to that concerned officer जे इटा को कैटेगरी रे आसुची एवं एटा से कैटेगरी रो नुहे
दीटा जाक से କଥା
that was otherwise से generally कहि दिला मोर पावर अछि मो इ करिपि तणु if you say that no it doesn't come within any of that then you are to because unless the attention is brought to the drawn to the notice of that concerned person you cannot behind his back without putting any question by using some that meaning from the dictionary or anything one whether it is permissible to just utilize it.
A question at the time of evidence. You must have to plead.
Right, that is the very fundamental
thing. You must have to plead.
Right.
And then justify your pleading by putting that suggestion in a course of evidence to the returning officer. He is your witness.
Right.
He is your witness. Therefore, you must be 100 times more cautious.
Because otherwise it would be just something that opportunity has not been given to explain and you are to utilize it against him like that. That when he has got the power if the power has not been properly utilized or illegally utilized, then these are the illegalities. You have no such power. That is to be specifically put, and so that you
put to him.
Get an opportunity to explain. If he gives any answer, whether it would be acceptable or not, that's a different matter.
Depends on the court.
All right. So, all right. Yes, sir.
And last paragraph, last suggestion under paragraph 26 in examination in chief is available at page 25 and 26.
25, 26. Just.
Bottom to
25 are going to.
पाइले ना
ठीक है हाँ सर 22 पेज हाँ 24 25 तो पूछंदी
हाँ 25 बटन
हाँ 25 रो बटन हाँ
जो जाती it is not a fact
25 रो
हाँ paragraph 26 page 25 and 26
no just a minute big what the PW2 evidence
PW3
just
returning officer
26 paragraph na
again
phone
your lordship
yes
come to bottom
got it yes
it is not a fact that in violation of the provisions contemplated under the Representation of the People Act 1951, the Conduct of Election Rules 1961, and Handbook for Returning Officer Exhibit 38, I accepted Exhibit 39, 40, 41 and 42 and Exhibit 43, 44, Exhibit 45 and 46. It is not a fact that I have not received the affidavit in response of the respondent under Exhibit 39(1), Exhibit 40/1, Exhibit 41/1, and Exhibit 42/1 on 2/4/2019. With this, their examination in chief is closed. Your Lordship has marked, which I beg to press before your Lordship, that substantial suggestions given by the election petitioner have been denied. Apart from what I have elicited in cross-examination. Despite that, there was no attempt on part of the election petitioner to declare him hostile and place any other witness in his place. No such application was moved before your Lordship. So, he stands as their witness, and whatever statements he has made, both in examination in chief as well as in cross-examination, can be utilized against the election petitioner.
Because he has not been.
Mine. Then my cross-examination starts from paragraph 30 at page 28 and 29. 28 रो से bottom को सर जान.
Exhibit AK.
Exhibit AK reveals. Exhibit AK reveals that the respondent Muhammad Mokim of Indian National Congress Party filed 4 sets of nomination papers, which I have serially numbered as serial number 2, 3, 4 and 5. In nomination paper serial number 2, 1 Abhishek Joshi was the proposer, whose name was registered in the electoral roll number, part number 143, serial number 706 of 90 Baravati Kotak Assembly constituency at the relevant point of time. In the nomination paper serial number 3, 1 Sheikh Liaqutuddin Ahmad was the proposer, whose name was registered in the electoral roll under part 102, serial number 857 of 90 Baravati Kotak Assembly constituency at the relevant point of time. In the nomination paper serial number 4, One Giribala Behera was the proposer, whose name was registered in the electoral roll under Part 21, serial number 1360 of 90 Baravati Kotak Assembly constituency at the relevant point of time. In the nomination paper, serial number 51, Rabinarayan Mallik was the proposer, whose name was registered in the electoral roll under Part 152, serial number 376 of 90 Baravati Kotak Assembly constituency at the relevant point of time. My Lord, what I beg to submit before your Lordship, these are only two primary requirements to accept the nomination of a candidate set up by a recognized political party. So the returning officer says that I verified these primary facts and accordingly I accepted the nomination of respondent. Kindly come to page paragraph 31 at page 31 and 32. Exhibit 38/3.
Bottom line.
Bottom line. Exhibit 38/3, that is Form 2B, indicates that a candidate set up by a recognized political party, that is recognized national political party as well as recognized state political party for the concerned state, is required to use Part 1 of the said form and required to be proposed by one elector of the concerned constituency as proposer. That has been complied with in the nomination papers. Exhibit 38/3, that is Form 2B, indicates that a candidate set up by a registered political party as well as
independent candidate
unregistered political party. Registered political party
to use Part 2 and required to be unregistered.
Registered unrecognized party. Registered unrecognized.
Unrecognized what omit
registered unrecognized political party as well as an independent candidate is required to use Part 2 of the said form and required to be proposed by 10 electors of the concerned constituency as proposers. Your Lordship got it?
Yes.
My Lord. Then paragraph 32 at page 32 to 36.
So that is detail has been given that
My Lord.
Who are the candidates, other candidates.
My Lord, my Lord. ସମସ୍ତଙ୍କର ସେ କହିଛି.
You skip over those things just.
My Lord, then all right. He is referring to in this paragraph to Form 3A, Notice of Nomination. If your Lordship sees, if your Lordship go one by one, your Lordship will find that total 11 candidates had filed their nomination and total 27 numbers of nominations were filed. 27 sets of nominations. Then your Lordship may kindly come to paragraph 34 at page 38.
Got it.
Exhibit 39 is the nomination paper filed by the respondent, which I have numbered as 02LA 2019, dated 2/4/2019, which was received by me at 11:20 AM, and it consists of 73 sheets apart from nomination papers, which includes other documents in connection with nomination of the respondent and it is in one bunch. Exhibit 39, that is Form 2B up to Part 4, is in 4 sheets. जोटाकु सेमाने करचंती 5 टाकु आउ कलेनी जोटा decision of the returning officer and they are challenging it, which we have marked. Exhibit 39, that is Form 2B up to Part 4, is in 4 sheets, and apart from it, Part 4, a 5 of Form 2B, which is my decision accepting the nomination paper of the respondent, is available, and it is in one sheet and marked as Exhibit AW. In Exhibit AW, I have taken a decision that the nomination paper of respondent Muhammad Mokim is valid. In accordance with Section 36 of the Representation of People Act 1951. And I have put my signature thereon with date on 5/4/2019, and the said portion is marked as AW by 1. In the first set of nomination papers filed by the respondent, numbered as 02/LA 2019, after AW, Exhibit 39 by 1 appears, which is the affidavit in Form 26, dated 2/4/2019 of the respondent, and it consists of 23 sheets. Here I beg to recollect that your Lordship must recollect and take a note that their contention is this affidavit that in Form 26 dated 2/4 was not at all filed.
Yes.
Was not at all filed. And I will specifically deal with it under paragraph 7b. After Exhibit 39 by 1, in that month, the original money receipt rupees 10,000 granted in favor of the respondent Muhammad Mokim, which is dated 29/3/2019, showing that it was issued from book number 88 of 2019, bearing serial number 0079343, which is towards security deposit by the respondent for 90 Baravati Kotak Assembly constituency, and the same is in one sheet and marked as Exhibit AX.
No, Mr. Mishra, the moment the checklist is proved, that shows that affidavit dated 2/2 has been verified. And there was existence of the affidavit dated 2/4, for which they were asked to file another because of
which was faulty.
So the question of there was no affidavit,
does not arise.
otherwise the checklist would not have been in existence. So yes.
ସେଟା ସ୍ପେସିଫିକାଲି 7B ରେ ସେମାନଙ୍କର ଆଲିଗେସନ ଅଛି, ସେଟାକୁ ମୁଁ ସ୍ପେସିଫିକାଲି ପ୍ଲେସ୍ କରିବି. And the said deposit has been made by the respondent in compliance with Section 34 of the Representation of People Act 1951. ଯଦି ଏଇଟା ବି ନଥାନ୍ତା, his nomination is liable to be rejected. Why I have brought all these factors to your Lordship's notice is to show that not only the returning officer has verified meticulously what he has repeatedly said in his course of evidence, but also he has checked up all the aspects, whether the nomination of the respondent is valid or liable to be dismissed on account of any non-compliance or substantial defect.
Right.
Then After Exhibit AX in the same bunch, photocopy of title page of bank passbook of Federal Bank Limited bearing account number so and so standing in the name of respondent Mohammad Mokim and Sheikh Intekhab Alam is there. Intekhab Alam is his election agent, additional election agent. And accordingly, according to the instruction, they have to maintain a separate account for the purpose of election expenses only. Now, which is in one sheet, and it was opened and activated on 30/3/2019, and the same is marked as Exhibit AY, which was filed by the respondent in compliance with Section 77 of the Representation of the People Act 1951, read with clause 5.30.1 of Handbook of Returning Officer, Exhibit 38. Chapter 5, Nomination, page 95. After Exhibit AY, in the same bunch, the photocopy of the final voter list for the year 2019 of 90 Baravati Kotak Assembly Constituency, Part 70 is there, wherein at serial number 1112, the name and photograph of the respondent appears, and it is in one sheet and marked as Exhibit AZ. The relevant portion of serial number 1112 is marked Exhibit AZ by 1. I have compared Exhibit AZ with the original voter list of 90 Baravati Kotak Assembly Constituency, and it tallied. On the date of presentation of nomination by the respondent, I got satisfied after verifying Exhibit AZ as well as the original voter list that the respondent is an elector of 90 Baravati Kotak Assembly Constituency. After Exhibit AZ in the same bunch, the original Form B, which is a notice as to the name of the candidate set up by the political party, is there, which was issued by the President Pradesh Congress Committee Orissa to me, wherein the name of the respondent finds place as the approved candidate of the Indian National Congress for 90 Baravati Kotak Assembly Constituency, and it is in one sheet, and the same is marked as Exhibit BA. After Exhibit BA in the same bunch, the original Form A, which is the communication with regard to the authorized person to intimate the name of the candidate set up by the recognized national party dated 18/3/2019, and the same has been issued by Mukul Vasnik, General Secretary Indian National Congress, to me, as well as to the Chief Electoral Officer, Odisha, wherein Sri Niranjan Patnaik, President, Odisha Pradesh Congress Committee, has been authorized to intimate the names of the candidates to be set up by the party for all assembly constituencies of Orissa, containing therein the specimen signature of Niranjan Patnaik, and the same is in one sheet and marked as Exhibit BB. Exhibit BA, Exhibit BB, which are Form B and Form A, respectively, of Indian National Congress, have been filed by the respondent only, and no other candidate of Indian National Congress has filed such documents in the election in question. Indian National Congress is a recognized national political party, and by filing Exhibit BA and Exhibit BB, the respondent is required under law to be proposed by an elector of the said constituency under Part 1 of Form 2B, and he is not required to be proposed by 10 electors of the said constituency under Part 2 of the form, and Part 2 of the Form 2B is not relevant for the respondent. This is material, my lord. This is material. Your lordship may kindly take note of this particular paragraph.
Yes.
ଏଥିରେ ବି ଆମରି ଓଡ଼ିଶାରେ ଗୋଟେ ଡିସିସନ ଅଛି ଆଠଗଡ଼ ଇଲେକ୍ସନ କେସ୍ ରମେଶ ରାଉତ ଭର୍ସେସ ରବୀନ୍ଦ୍ର ରାଉତ ରଣେନ୍ଦ୍ର ପ୍ରତାପ ସାଏଙ୍କ କେସ୍ ସେଥିରେ ତାଙ୍କର ଥିଲା ସବୁ ସେ ଫିଲଅପ କରିଥିଲେ ତାଙ୍କର କାଟିଦେଲେ ରିଟର୍ଣ୍ଣିଂ ଅଫିସର ଯେତେବେଳେ ଚେକ୍ ଲିଷ୍ଟ ଦେଲେ ଆଜ ୟୋର ଲର୍ଡସିପ ଇଜ ସଜେଷ୍ଟିଂ he indicated that he received part form A and B signed in ink. କିନ୍ତୁ ଯେତେବେଳେ ସ୍କ୍ରୁଟିନି କଲେ ଆ ଭିତରେ ଇନ୍ ବିଟୁଇନ୍ ଚେକ୍ ଲିଷ୍ଟ ଯୋଉଦିନ ରିସିଭ୍ କଲେ ଦେଲେ 4 ତାରିଖ ଦିନ 6 ତାରିଖ ଦିନ ସ୍କ୍ରୁଟିନି କଲେ ଇନ୍ ବିଟୁଇନ୍ ତାକୁ ଜେରକ୍ସ କରିବାକୁ ପଠେଇଥିଲେ ସେ କାଟିଦେଲେ alleging that ତାଙ୍କର form A and B not signed in ink. That is a Xerox copy. Though he was proposed by one proposer under one party, under part 1, being sponsored or set up by a recognized state political party, Biju Janata Dal. We carried an election petition here. We won. That was challenged in appeal. In appeal, that was also sustained. Same 2012 decision. Now, after Exhibit BB in the same bunch, the photocopy of the voter identity card of the respondent is there, which is one sheet, and the same is marked as Exhibit BC. After Exhibit BC in the same bunch, the photocopy of the PAN card of the respondent bearing PAN number so and so is there, which is in one sheet. Same is marked as Exhibit BD. After Exhibit BD in the same bunch, photocopy of the Aadhaar card of the respondent bearing number so and so is there, which is in one sheet, and the same is marked as Exhibit BE. After Exhibit BE in the same bunch, the photocopy of the provisional educational certificate of the respondent issued by Utkal University is there, which is one sheet, issued on 28/1991, valid certificate number so and so, showing that the respondent has passed BE electrical, and the same is marked as Exhibit BF. After Exhibit BF in the same bunch, the photocopy of the BE electrical mark sheet issued by Utkal University is there, which is in one sheet, and the same is marked as Exhibit BG. After Exhibit BG in the same bunch, the photocopy of the certificate of high school certificate examination issued by Board of Secondary Education Orissa is there, which is one sheet, showing that the date of birth of respondent is 3rd July 1965, and the same is marked Exhibit BH. Exhibits BH, BC, BD, BE, and AZ indicate that the respondent has completed 25 years of age at the time of filing of nomination in the election in question, and he is qualified as prescribed under Article 173B of the Constitution of India. After BH in the same bunch, the original form of oath or affirmation of the respondent is there, which is in one sheet, wherein I have certified that the respondent has taken oath before me on 2/4/2019 at 11:20 a.m. as required under the law. 11:28 AM as required under law, and the same is marked as Exhibit BJ. The signature of the respondent in Exhibit BJ is marked Exhibit BJ by 1, and my seal and signature thereon is marked as Exhibit BJ by 2. The respondent has subscribed oath before me at 11:28 AM on 2/4/2019 after presenting the nomination papers to me on 2/4/2019 at 11:20 AM. This is material. Why, my lord? Law enjoins that the oath is to be taken after presentation of the nomination. If this would have been taken before the presentation of nomination, then on that count also, the nomination is liable to be rejected. ବୃନ୍ଦାବନ ମାଝୀ କେସରେ ଆମ ଓଡ଼ିଶା ହାଇକୋର୍ଟର ଏଇଠି ସେୟା ହୋଲ୍ଡ କରିଥିଲେ. And Justice Sharat Mahapatra was the election judge then. After subscribing oath by the respondent, I issued this certificate for receipt oath, which is already marked as Exhibit T, wherein I have endorsed that the respondent has subscribed oath affirmation on 2/4/2019 at 11:28 AM. The seal and signature of mine in Exhibit T is marked as Exhibit T by 1. Exhibit BJ and Exhibit T indicate that the respondent is qualified to be chosen to fill a seat in the state legislature in election in question as prescribed under Article 173A of the Constitution of India. ତାପରେ ଆପଣଙ୍କର ନିଜର କେତେଟା କ୍ୱେଶ୍ଚିନ୍ ଅଛି.
We'll continue tomorrow. Same time, 3 o'clock.
Minor. 15 Hmm.